Hello, good evening. Hope you are hearing me clearly. So this is second day of our revision, right? And yesterday we have looked at about 4 questions. And normally for evidence, I can only look at very few questions because naturally, as all of you know, the questions are extremely long and the issues are quite a lot, right? So we cannot look at many questions because to finish up one question itself, it takes a lot of time for us, right? Due to the length of the question. If it is like European Union law, usually I will look at in this type of classes, I will look at 20 questions, right? In one revision class for 3.5 hours, but it isn't possible in evidence. So yesterday, I've actually promised you to give the article, right? Remember, I've actually told you that I will pass you the article that was listed in the recent development, right? Which is in regards to RAG-ST, right? So this is the article I'm uploading in the chat room. And I will also pass one copy to Speed officially, right? So that you will get an official copy from Speed as well, right? But this is the article. If you guys want, tomorrow I will give you the summary of the article itself. I couldn't able to do the summary today. So if you all want, I can just pass you the summary. I've read that article, not very difficult to read, right? It is in a, not too much of a legal jargon. It is actually in a simple English. Anybody can understand. And the article essentially trying to say that we should abolish RAG-ST in US. In US, RAG-ST is known as excited utterance. And they said that we should also abolish this in United Kingdom. So for both jurisdiction, they have given some cases. For US, they have given some cases. For UK, they have given some cases where it doesn't make sense to rely on RAG-ST. Or the entire RAG-ST doesn't make sense in these cases altogether, right? And they have included some scientific research principles to show that they've used some scientific biological terms. I think neuro-linguistic or something. Essentially, they are trying to say your brain doesn't work that way, right? Some people, when you step them, they shout after 10 seconds. Some people, when you step them, they shout after 2 minutes. Some people don't shout, direct die, right? So we cannot actually, assume that if I step you and immediately you shout, it is admissible, right? If I step you after 10 seconds or 20 seconds, you shout, it's not really admissible, right? So the article is trying to say that, this is like, it doesn't make sense. And they said that please go into 114 sub 1D, right? Whatever you cannot include or doesn't make sense, straight go on and include it in 114 sub 1D. It's a question or something, is it? Thanks a lot for the article. It would be good if you would provide a summary. Yes, definitely. Right. I was actually doing summary today, but I don't have only half of the summary available now. I already did half. So I'll finish it off tomorrow. Then I'll pass you all the summary as well. So you can go on and read the summary. Now, again, as I told you guys yesterday, please read the article, or at least please read the summary. If you don't have time to read the article, please read the summary, because I can tell you for sure that RAG-ST is coming out, right? It could be an essay, right? Or it will be a problem solving question on RAG-ST, where the examiners will say, please, the usual thing in evidence law, problem solving question, they will put, please discuss where the law is unsatisfactory, the last 2 lines. So they would expect you to include that article even in a problem solving question. So please remember, if this year you get a RAG-ST problem solving question, right, you have to discuss this article, even if it is a problem solving question. If it is an essay question, obviously, yes, you have to include this article and all, right? So don't forget that, right? And one more thing that I want to pass it to you. Whatever I'm passing here, I will pass a copy officially to Speed as well, right? This is actually a 2022 questions, evidence questions, which is something that we will go on and look at today, including some other questions. 2023, I will look at tomorrow. As I told you, 2023, I will look at tomorrow. Yesterday, we have looked at 2021, 2020, 2019 also. Yesterday, we have looked at. But today, we will look at 2022 and probably 2021. right? Still 2021. Then after that, tomorrow we will look at 2023. Once you are familiar, then 2023 will not really cause a lot of problem to you. Okay. So that is 2022 evidence answers. Anybody cannot download this, right? If you can't download, or if you think that, I cannot instantly open, then I'll just pass via your email. Anybody cannot open this, just put your email. Right? If you can open, just open and look at it now. I will pass to Speed later, right? Probably by tomorrow, I'll pass the notes to them. So you will get this latest by Friday. Okay. So 7 people. Right. Okay. So I'm going to open the notes now that I posted. And we are still going to look at problem solving questions. If I have time, I will look at essay question today. I've given you essay question answers as well, right? In my outlines that I passed to you earlier. Okay, can you see question 5, 2022 zone B? Right? See, there's a reason why I'm looking at a lot of problem solving questions. Many students do ask this. Number 1, essay question, I can finish this very fast. Right? Number 2, essay questions in evidence are killer questions. It's not that easy to do essay questions. Sometimes they ask you certain things that is too in-depth that nobody knows what it is. Right? So essay questions are killer questions. The examiner's expectation on you is very, very high. Problem solving questions may look like very long, but the moment you know the issues and you know the package of sections, the package of cases, you know how to answer. Right? You can somehow get marks in problem solving question, but essay question, if you are wrong, you are wrong. That's all. There's no courtesy marks given for essay questions. Problem solving questions, sometimes, yes. Right? If you miss few things, you can still get marks. You can still pass. So please be very careful in doing essay questions. Although I will look at essay questions later. Okay, so please look at question 5, 2022 zone B. Right? And remember, before I start to read the question, remember, there's no such thing called hearsay question. There's no such thing called bad character evidence question. There's no such thing called confession question. All will come out in one problem solving question. So I cannot distinguish, right? Today is bad character, tomorrow is hearsay, the day after tomorrow is something else. Okay, let me read. Acting as an undercover police officer in an unauthorized operation, in an authorized operation against local drugs in the Batesbury area, Adil regularly visits Batesbury Arms, a local bar notorious for being a hub for drug dealing. One evening, he overhears a conversation in the bar in which Boris tells Charlie, Donald has the best supply for cocaine. Look at that statement. Huh? Donald has the best supply for cocaine. His phone number is 07798692104. Full stop. Adil does some background check and discovers that Donald has one previous conviction for possession of marijuana, a class C drug, with an intent to supply from 1 year ago. So this conversation between Boris and Charlie was overheard by Donald. Donald is actually an undercover police officer, which automatically triggered discussion in regards to hearsay. Right? If you look at this question, it's very similar to the question that we have looked at earlier, yesterday. Right? This is almost the same situation. A spy officer, right? He overheard the conversation. Remember, he said that, I'm going to rob a bank. Right? This is one of the questions that we have looked at yesterday. Very, very similar. Right? And that was 2021. This is actually 2022. That is actually the difference. Other than that, everything is the same. This question recycling is happening very, very frequently, right, in evidence law. Okay. So, let me continue. Adil does some background checks and discover Donald has one previous conviction, past conviction, for possession of marijuana, a class C drug, with intent to supply from 1 year ago. That's bad character evidence. Without telling his superiors in the police force. Look at that again. Without telling his superiors in the police force. Earlier, the question stated it was an authorized operation. Right? It was an authorized operation. But apparently, it seems now he is doing something without telling his superiors in the police force. Adil texts Donald on the phone number without telling his superiors. Adil texts Donald on the phone number mentioned by Boris, saying, I hear you can get me something I need. Donald does not reply. So Adil then sends Donald another text message saying, whatever your normal price, I will pay double. I'm a desperate for a fix. Look at that line again, because this is a spy operation. And yesterday, while we were looking at the case of Crown against Loosely, what the court stated, right? In order to exclude evidence, right, or stay the proceedings as an abuse of process, we have to see what type of role that the police officer took, right? Whether he took a role of an active agent, that means like telling you that let's go and rob. I will teach you this, I'll teach you that. Or he just took a passive role. He just gave you an opportunity. But here it seems he's telling that whatever your normal price, I'll pay double. I'm desperate for a fix. The statement later you will have to consider whether the police officer is taking an active role or passive role. Donald then agrees and specifies a meeting and a time. When Donald goes to the agreed meeting, he's surrounded by police who find large quantities of cocaine in his jacket pocket. He's arrested and cautioned in connection with possession of Class A drugs, but his request for a lawyer is denied by Police Superintendent Edwards, who says, you have been arrested before, so you already understand all you need to about your rights. But if you insist, we can get you a lawyer, but that could take 2 days. So that's a refusal of legal advice here. Yesterday, we have looked at this. Section 58, Annex B, Code C. Right? Section 58, Annex B, Code C. There's actually a little bit of difference on the facts of this case, because on the facts, the person delaying the legal advice is Superintendent Edwards. Superintendent have the right to delay legal advice. They always have the rights. In almost all the questions that we have looked at yesterday, refusal of legal advice was in regards to an inspector or police constable authorizing it. But here, apparently, who's authorizing it is the superintendent. But the reason that he has given may not be right. Right? We will look at that later. Donald is held in a cell without food or drink for 16 hours. This is Code C breach. Right? 16 hours. And then agrees to be interviewed without a lawyer present. He quickly admits that he got the cocaine for Adil, but adds, I normally only deal in low-level drugs. But he offered me a price I couldn't resist. There's a confession here. Right? There's a confession. Because he said that I normally only deal in a low-level drugs, but he offered me a price I couldn't resist. So this looks like a mixed statement, right? Not fully inculpatory, not fully exculpatory, but it's a mixed statement. I did this, but he asked me to do something like that. Adil will not appear at the trial as he has to go into hospital for a major operation, right? Who is Adil? Adil is actually the the undercover police officer, right? So he won't be coming to court. And if he's not coming to court, then probably his witness statement or something will be read in court, which will probably trigger another hearsay issue. Discuss the evidential issues arising, adding critical comment where you think the law is unsatisfactory. Right? That's the usual last 2 lines you will see, right? Asking you to discuss about where you think the law is unsatisfactory. So we will go into the discussion. First, see, there's no particular structure that you have to follow here. It's your wish. If you want to discuss hearsay, you can discuss hearsay first. You want to discuss confession, you discuss confession first. Right? So you don't have to follow my structure. I'm starting from the first paragraph, second paragraph, third paragraph, like that. But my advice is, sorry. My advice is, you do the way that you are comfortable. Okay, so I'm starting from entrapment. Entrapment means evidence obtained by trick. And on the fact, Adil has obtained some evidence by trick, and we are going to exclude that evidence. Right? So there's an enticement. Right? There's an enticement. And because of that enticement, we are going to exclude the confession. Right? We are going to exclude the confession because of the enticement. Right? What is the enticement? You can see the enticement here. The enticement is Adil texts Donald on the phone number mentioned by Boris, saying, I hear you can get me something I need. Donald does not reply. That's the first enticement. You are encouraging him. Then after that, Adil sends Donald another text message. Whatever normal price, I'll pay you double. I'm desperate for a fix. So we are going to exclude the confession that who's that Donald has actually made because of entrapment, evidence obtained by trick. But if you want to do that, then we have to see whether Adil, being an undercover spy officer, whether he has taken an active role or passive role. And for that, we have to go on and look at the case of Crown against Loosely. Right? And in Crown against Loosely, whether you want to write the facts or not, it depends on you. I don't stop you if you want to write the facts, but the facts are not really important. Right? The facts are not really important. So in the case of Crown against Loosely, Lord Justice Nichols, right, he stated this: whether the conduct of the police amounted to inciting or instigating crime was to ascertain whether the police did more than present the defendant with an unexceptional opportunity to commit a crime. Did they just give you an opportunity, or did they gone more than that? That is the idea here, right? That is the test, right? If you don't want to write all these things, you can just write this. What Lord Justice Nichols stated was, did the police just gave you an opportunity and you took up the opportunity? If this is the case, this is number one. If this is the case, then evidence will not be excluded, right? We can't exclude the evidence because we presume you did this on your own. Evidence will not be excluded. But if the police took active role, then we have to go on and consider whether we stay the trial or we exclude the evidence. When I talk about exclude the evidence, I'm talking about confession evidence here. When you write like this, the examiner will be very impressed. Let me tell you, many students think that section 78 here, which is the section that we are using to exclude the evidence, right? Section 78, what type of section is that? 78? When there is an adverse effect to the fairness of the proceedings. Whenever there's an adverse effect to the fairness of the proceedings, the evidence ought not to be included, right? We have looked at this even yesterday, right? I have actually explained this particular thing to you even yesterday. Okay, just give me a second. There are newcomers, so I will just re-upload the notes again, right? This is the notes that I'm referring to now. Okay, so after you discuss this, if you go on and tell the examiner that we can stay the process, the examiner will be very impressed with you, right? Because not many people will know this. Lord Hoffman said this. Lord Hoffman said, see here, under number 2, entrapment to stay the prosecution on the ground that the integrity, please look at this carefully, you will stay the prosecution on the ground that the integrity of the criminal justice system would be compromised by allowing the state to punish someone whom the state itself caused to transgress. So when we will stay the proceedings, what is stay means? Completely stop, right? There's no prosecution at all, completely stop. We will stay the proceedings if the integrity of the criminal justice system is affected, right? But if you look at number 3, although the court has discretion under 78 of Police and Criminal Evidence Act 1984 to exclude evidence on the ground that its admission would have an adverse effect on the fairness of the proceedings, the exclusion of evidence is not an appropriate response to entrapment. Look at this back. Excluding evidence on the ground that its admission would have an adverse effect on the fairness of the proceedings, the court stated the exclusion of evidence is not an appropriate response to entrapment. Why? Why excluding evidence is not really appropriate response to entrapment? Because you look at this question here. You look at our question, right? There's nobody punch you, there's nobody beat you or whatever. You were in a cell without food or drink for 16 hours, right? And he quickly admits that he got the cocaine for Adil, but adds, I normally deal in low-level drugs, but he offered me a price I couldn't resist. He confessed. There's a confession. Of course, confession can be excluded. I do know. It may be obtained by oppression. It may be obtained by something said or done. right? But when accused himself confess, it is actually a very, very credible and cogent evidence that he has committed the crime. So if you go and exclude the evidence, it is actually a shameful thing to the entire criminal justice system. When someone come and tell you that I committed the offense, you are telling no, you didn't commit. That's the reason Lord Justice Hoffman trying to say entrapment, Section 78, exclusion of evidence, is not really an appropriate response to entrapment. But you can still do that. But it's not appropriate. That's what he's trying to say. He's not trying to say you can't exclude, but it is not an appropriate response. So what is an appropriate response? If the policeman took an active role, then you go on and stay the process. Right? You go on and stay the process. That would be an active role. Do you get this? You should able to explain like this. You should tell the examiner if you want good marks, rather than you telling this evidence will be excluded, which is the whole world will discuss like that. If you want good marks, you must able to tell the examiner that when the entire trial will be stayed, when we can exclude the evidence. So it will be impressive. Do you get this? So on the facts, did the police officer here, Adil, played an active role or passive role? It seems he stated that I will pay you double. Right? He stated that I will pay you double. Well, paying double is probably, you can say that just an encouragement. If you are really an honest, a disciplined person, why you are swayed by all these things? Right or not? But if you look at this type of cases before, right, this type of cases in regards to purchase of drugs by police, right, I have actually given some cases here. In those cases, entrapment was not accepted by the court. The court stated the policeman did not play an active role. The policeman played a passive role, not an active role. One of it is Crown against Shannon. There's actually a YouTube documentary about this particular case as well. You just have to type Operation Fake Shake. In YouTube, you can see a documentary on that. Right, Operation Fake Shake in United Kingdom. It was actually an operation by the police force where these two people, Shannon and another person, they were actually, tricked by the police to supply drugs to them. Right, and the police even went to the extent of, faking passport. They are coming from overseas. They even fake the passports and give to these people, and they came, the police arrested them. Right, so you can see what the court stated here. In the Court of Appeal, Porter Lord Justice stated, it is insufficient that the unfairness complaint relates to the fact that the defendant would not have committed the crime but for the incitement of others, unless the behavior of the police or the prosecuting authority has been as such to justify as an abuse of process. The court stated you were just given an opportunity, right? You were just given an opportunity and you used that opportunity. The policeman did not take an active role. Please remember, court is not a place to discipline the policeman. I repeat again, court is not a place to discipline the policeman. Then you go to Crown against Latif Shahzad. Can you see? Crown against Latif Shahzad. Again, the passport faking case is actually this one. Yeah, sorry. Right, Operation Fake Shake is actually about, police set up an operation to find out who's actually buying drugs. But the passport and, the police faking passport that I told you is this case, Crown against Latif and Shahzad. Right, that is the case where two drug traffickers, the police even given them visa, prepared a visa for them, prepared a fake passport for them. When they landed in airport, the police went and seized 3.2 million worth of heroin, one of the largest seize ever. So they said that, the police even prepared a visa and passport. How could you say that this is not a police taking an active role? Do you think a police will normally prepare a visa and passport for you to come from Pakistan to UK so that we can arrest you? And moreover, that's actually a fake visa, fake passport created by the police, not the original passport, not the original visa. Still, the court stated that there's no abuse of process. right? There's no abuse. So which means the court is very adamant that this is not a place for us to discipline the policeman. And therefore, on our facts, I think I think entrapment cannot be used as a defense. Right? I don't think entrapment is a defense. Do you understand this? So if you ask me, is there any case that the police took an active role? Yes. Throughout the history of United Kingdom, there's only one case. That's the case of Crown against Mason. You guys may remember reading this case. Crown against Mason is where the police went and lied to the lawyer, not to the accused, lied to the lawyer that we found your fingerprint in the glass and therefore confessed to the crime. And he went and confessed. And the court stated, lying to the lawyer is something that they can't take. It's too much already. Because lawyers are also officers of the court. You cannot be lying to them. Okay, so section 78 is not applicable on the facts. So if section 78 is not applicable, then we have to go on and try whether can we exclude this under section 78. Right, this is a typo here. On the fact, it's supposed to be Donna. Right? It's supposed to be Donna. Okay. So do you all understand why I'm going to 76 sub 2A, 76 sub 2B? Right? Because it seems that the confession on the fact that cannot be excluded by using section 78. So therefore, I'm going into 76 sub 2A, 76 sub 2B. Why we went to 78? Because we want to exclude the evidence due to entrapment. Evidence obtained by trick or ill-gotten evidence. But it seems we can't do that. So we go to 76 sub 2A and 76 sub 2B. If you want to get a good marks, right? If you want to get a good marks, before you discuss section 76 sub 2A or 76 sub 2B, you discuss section 76 sub 1 first. If you want good marks. Obviously, you can straight go into 2A and 2B. But if you want good marks, you do that. Right? That's a proper structure. 76 sub 1 stated, all confessions are admitted, provided it is relevant and it is not excluded under 76 sub 2A or 76 sub 2B. So confession is admitted provided it's relevant and it should not have been excluded under 76 sub 2A or 76 sub 2B. On our facts, is a confession is relevant? Any confession is always relevant, right? Because I am confessing that I committed the crime. How could you say that it's not relevant? What is relevant means? If you guys, stuck in your exam question and you're thinking, is this relevant or not? Remember, any facts proving facts in issue is considered relevant. So, any facts proving facts in issue. What is the facts in issue? In criminal trial, facts in issue is always, right? In any criminal trial, facts in issue is always AR, MR, and defense. So, any facts proving AR, MR, defense is relevant. Any facts proving AR and MR is considered to be relevant. So, on our facts, is a confession is actually proving the AR and MR? Yes, it's proving both. It's proving AR and MR both. Therefore, it is said to be relevant. So, we have already satisfied the first part under 76 sub 1. Now, 76 sub 2A and 2B, we have to discuss. If it is not excluded under here, then the confession is admissible. Okay, so we'll go on and look at 76 sub 2A, something that you guys already know. 76 sub 2A is about oppression. And remember, for 76 sub 2A to be applicable, there must be a bad faith by the police. Right? That means police have acted in bad faith. When they punch you, they want to punch you. It cannot be I'm doing something, I'm busy, and then my elbow accidentally hit you like that. And you say that, oh, police torture me. But then I will come to court and say, Judge, I was very busy and accidentally my elbow hit his face. And he's telling that, I've tortured him. If it is accidental, you cannot go under 76 sub 2A. Because for 76 sub 2A to be applicable, there must be a bad faith by the policeman. The policeman really wanted to do this to hurt you. So what is oppression means? In this section, right, 76 sub 8, that is the definition, statutory definition of oppression. Includes torture, inhumane or degrading treatment, and the use of threat of violence, whether or not amounting to torture. My advice is, don't discuss both of this. Yesterday, we have looked at Crown against Fulling, which is also definition of oppression, but that is actually a case law definition. This is statutory definition. My advice is you should go for statutory definition. Right? Now, there's nothing wrong in common law definition, but you see common law definition is too long. You don't want to waste your time writing this down. Right? And this one is like very compact, precise. So just go on with that. Go on with 76 a bit. So on the facts, is there an operation? Adil and teasing Donald. Right? You must keep encouraging. I'll give you double. Operation is not only physical operation, mental operation also operation. Right? Mental operation also operation. So it's not only physical operation, mental operation also operation. And also Donald is held in a cell without food or drink for 16 hours. Isn't that considered to be an operation? How do you feel when you don't have food for 16 hours and somehow you are in prison? So I would probably consider this as a inhumane or degrading treatment. And therefore, probably the confession can be excluded under 76 sub 2A if the court decided that there is a oppression here. Remember, if there is an operation, 76 sub 2A, 76 sub 2B is not a discretionary section. If there is an operation, the judge has to exclude. It's mandatory. He must exclude this confession. Compared to 78 that we have looked at just now. 78 is discretionary. Right? But 76 sub 2A is actually mandatory. Anybody have any question here? Okay. We have no question. Then we go to 76 sub 2B now. Section 76 sub 2B is something said or done. Yesterday, I have given you 3 requirements to satisfy under 76, to satisfy 76 sub 2B. You will write the same requirement. Number 1, there must be something said or done. This something said or done must come externally. That means must come from anybody. That means like not necessarily policeman, right? It can be anybody. It's like you have committed murder and then your wife comes to you and said that please admit, right? If you really love me, please admit that you committed this murder. And you went and confess. Later you want to exclude the confession. Now something that you said, there's something said or done by your wife. That's the reason you have confessed. So even whatever your wife did can be considered to be something said or done. But the something said or done must come externally. It cannot be internal. Internal means like you thought, if I go on and confess, the policeman will probably release me. If you do that, then that's not external. That's internal. Then number 2. Right? Number 2 is the principle in regards to causation must be satisfied. Right? That means that something said or done must have caused your confession to be unreliable. These are the 3 requirements that you have to satisfy. The most important requirement is requirement number 1 only. Something said or done must come externally. Okay. So, what we'll do now, we'll go on, when you discuss 76 sub 2B, you go on and cite the case of Crown against Goldenberg, 1989. Where Goldenberg is a heroin addict. He went and confessed to the police on his own. Police did not say anything. He thought that if he confessed, he can be released from the lockup fast. But the court stated something said or done here comes internally, not from external. Okay, there's a question here. Come externally for 76 sub 2B means a third party other than D, right? Yes. Right? You are right. No need to be police. Right? But usually it is police, but no need to be police. It's a third party except for the accused or the defendant. Can be anybody else except for you. Do you get this? So that is Crown against Goldenberg. Right? And you can discuss either one case here. Right? Crown against Crampton, Crown against Paris. Crown against Paris is actually a very good case as well. The full name of this case, Crown against Paris, Miller, and Abdullahi. That's a full name. Right? I'll write the full name of the case here. Crown against Paris, Miller, and Abdullahi. That's a full name. You know what the police did here? 300 times. They asked the same question. Did you do? No. Did you? No. Did you? No. Did you do? No, 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 no. Suddenly you said yes, they arrested. And the court stated here, something said or done comes externally from the policeman as well. So on our facts, was there anything external? I think yes. Right? Because they have actually did not give him food. Right? They left him just like that for 16 hours. The policeman have enticed him. Right? I will pay you double. Right? But I will pay you double is actually the part that he committed the crime. Right? So what lead to the confession? Right? Not to the crime. So confession is only 16 hours. So the only thing you can write here is 16 hours putting a person like that will obviously lead to some sort of a frustration, and definitely he will go on and confess. Right? And therefore, the confession may be excluded under 76 sub 2B as well. Do you understand? Anybody have any question? Okay. So what we'll do now, the next part. We have some code C breaches here that I told you, right? Which is for 16 hours, they didn't give him food. For 16 hours, they didn't give him anything, right? So there have been procedural irregularities. And therefore, we have to try to exclude this under 78 or 82 sub 3. Now, remember, just now we used section 78, right? But that was for entrapment, right? That was for entrapment, meaning evidence obtained by trick. But right now, it is not for entrapment. This is for code C breaches. Remember, while I did not look at confession with you in lectures, but then I think Miss Linda or Mr. Sanjay must have looked at this with you during the lectures, and they must have explained this to you, code C breach, right? There's a question. Sorry, does it mean that evidence should be excluded under 2A due to that 16 hours operation? 76 sub 2A not work. It is still excluded under 76 sub 2B. Is that the logic? Yeah, you can use 2A or 2B. Doesn't matter. You can even use both also. No issues. Right? It can be under 2A. It can be under 2B. Right? So your question is, does it mean that evidence should be excluded under 2A due to that 16 hours? Yes. But if 76 sub 2A did not work, it is still excluded under 2B? Yes. Right? If 2A, it is not excluded, 2B, it can be excluded. If 2B is not excluded, can 2A, it can be excluded? Yes. Can it be excluded under both? Yes. There's no problem at all. Right? You can exclude under both. You can exclude under either one. If this is applicable, that is also applicable. If that is applicable, this is also applicable. Okay, so you must have looked at code C breaches with Mr. Sanjay or Miss Linda. Not all code C breaches are coming out frequently. I'm going to show you what code C breaches are coming out in exam frequently and what code C breaches that you must remember, not remember, but you must know. Right? So I go to code C first. There are only a handful of code C you have to know for your exam. As I told you, not all code Cs are coming out. Okay. So can you see here? Code C. Right, this is code C. And the first one that I want to look at, you. Here. Okay, the first one I want to look at is, I cannot go down. Okay, the first one I want to look at is code number 5. Can you see code number 5? If you can, please take note of this code because it will be tested in your exam. These are the codes will be tested in your exam because it has so many codes. Okay, so 5.1 or code number 5, a right not to be held incommunicado. Subject to paragraph 5.7b, any person arrested and held in custody at a police station or other premises may on request have one person known to them or likely to take an interest in their welfare inform at public expense of their whereabouts as soon as practicable. If the person cannot be contacted, the detainee may choose up to 2 alternatives. If they cannot be contacted, the person in charge of detention or the investigation has discretion to allow further attempts until the information has been conveyed. This is always tested in exam, right? Whether can I actually communicate with anybody right after my arrest, right? And when it can be refused. See, when it can be refused, you can see here. Okay. Can you see this part? Any delay or denial of the rights in this section, 5.7 capital A, should be proportionate and should last no longer than necessary. You must know this as well. 5.1, 5.7. Remember, you have to know. Then we go to legal advice. Right? Can you see legal advice? Code C number 6. Code C number 6. Remember, this is the same thing that we see in 58, section 58 of PACE as well. And it is the same thing that you see in Annex B as well. Right? So, 6.1. Unless Annex B applies, all detainees must be informed that at any time they can consult and communicate privately with the solicitor, whether in person, in writing, by telephone, and that free independent legal advice is available. Right? So you must know section 6.1 and you must know section 6.6. Right? You must know section 6.6, which is when you can delay that. Right? Can you see? A detainee who wants legal advice may not be interviewed or continue to be interviewed until they receive such an advice unless an officer of superintendent rank above has reasonable grounds. And these are the reasonable grounds. Right? This is always comes out in exam. So you should know this. Then apart from that, code number 8. Can you see code number 8? Please mark this or take down the numbers because these are the codes that will be tested in your exam. Because this year I know that you must go to the exam center and do your exam, right? So, so although it's an open book exam, but you still have to carry your statute book. I don't think you can use computer, right, to search for anything. So you have to know, right, what you are going to do based on your statute book. Okay, so can you see section 8 under code C? Condition of detention, this always comes out in exam, right? 8.1. So far as practicable, not more than one detainee should be detained in each cell. Only one detainee in each cell. 8.2. Cells must be adequately heated, cleaned, and ventilated. Adequately lit, subject to such dimming condition, compatible with safety and security to allow people detained overnight to sleep. No additional restraint shall be used with a locked cell unless absolutely necessary. They cannot lock your hand, right, with a pole or something. Right, this always comes out. 8.3. Blankets, mattress, pillows, and other bedding supply shall be of reasonable standard and clean and sanitary condition. Always comes out as well. 8.4. Access to toilet right, always comes out 8.5 as well. If it is necessary to remove detainees' clothes for the purpose of investigation, for hygiene and health reasons or cleaning, removal shall be conducted with proper regard to dignity, sensitivity, and vulnerability of the detainee. If you want the detainee to remove the clothes. And 8.6, which is what we are dealing with in our current question. At least 2 light meals. At least 2 light meals. And 1 main meal should be offered in any 24 hours period. Right? But they did not even give him food here for 16 hours. Drink should be provided at meal times and upon reasonable request between the meals. Nothing was given to him. Right? So in our question, there's a 8.6 breach. That's all. All right. All others, you don't really have to focus so much. Right? Except for this. Sometimes I have seen 12 comes out. Right? Sometimes. But okay, I'll just look at that as well. Although it comes out very rarely. 12. Take down the quotes, sir. These are the quotes often tested. 12.2. Can you see 12.2? Except as below, in any period of 24 hours, detainee must be allowed a continuous period of at least 8 hours rest, free from questioning, travel, or any interruption in connection with the investigation concern. Right? The detainee must be allowed to rest for 8 hours. Right? And yeah, that's all. These are the only codes that will be tested in exam. No other codes will be tested. These are the only codes. So with that, if you go to our question, as I told you, there's some code C breaches here. So also I told you that we have to exclude these breaches. Can you see 8.6? Which is what something that I've looked at. At least 3 meals should be offered within any 24-hour period. Drink should be provided during meals and upon reasonable request. And just now I missed 12.8. Breaks at recognized meal time and short refreshment break at intervals of 2 hours. Nothing was done here. Because on our facts, he was questioned for 16 hours. Right? 16 hours. And also, right after this, write down these 2 cases, Keenan and Kennelly. In Keenan, it was stated that only significant and substantial breach will be excluded. That means one single breach will not warrant an exclusion. I repeat, one single breach will not warrant an exclusion. There must be a collection of breaches. If it is just one breach, I don't think so. The confession will be excluded. Anybody have any question? Anybody wants to ask me anything? Okay. Now we go to refusal of legal advice. As you can see, there's a refusal of legal advice on the facts of the question. Right? If you look at the question, see, he's arrested and cautioned in connection with possession of Class A drugs. But his request for a lawyer is denied by Police Superintendent Edwards, who says you have been arrested before, so you already understand and all you need about your rights. But if you insist, we can get you a lawyer, but that could take 2 days. There is a refusal of legal advice here. And when there is a refusal of legal advice, this is the package that you must discuss. Section 58, Code C, Annex B. Actually, you just have to discuss Section 58. After discussing Section 58, you just have to tell the examiner the same thing was mentioned in Code C, number 6 and also Annex B. That's all. You mark my word. Just adding these 2 words there will give you a lot of marks. You don't trust me, you take any examiner report, including 2023 examiner report. Take and see. The examiner stated, it is very disheartening that many students don't know whatever in Section 58 is also in Annex B, is also in Code C. Okay, so Section 58. if you want to deny legal advice or delay legal advice, then first of all, it must be an inductible offense. Right? On the fact, what offense is this? Drugs. So definitely drugs is actually inductible offense, serious offense. Then number two, the police officer of at least superintendent above authorize it. On the facts, we have superintendent as well. Right? We have superintendent on the facts. Number three, there must be reasonable grounds for that belief. And what will be the reasonable grounds? It may interfere with evidence, right? That means we cannot get back the evidence, right? If you get the lawyer, because lawyer will normally go and take the evidence and hide it somewhere, right? It may alert the accomplice. It may hinder the recovery of the property, which is the same thing I told you just now. You must satisfy either one of this, any one of this, but you must satisfy this and this for sure. This and this must be satisfied, and any one under here. Do you get this? Okay. So, if you have no question, then we have to go on and look at two cases under here. Crown against Allardyce, Crown against Samuel. Can you see that? In Crown against Allardyce, the court stated, consulting a lawyer is actually your fundamental rights. It's your legal right to consult a lawyer. If there's any refusal to consult a lawyer, it is a very, very significant breach. That's number one. Then Crown against Samuel, 1988. Right, Crown against Samuel, where the court stated, if you don't need a lawyer because you know about the law better than a lawyer because you are a regular customer in prison, right? You always come to prison. So you don't need anybody. Then probably we will probably take that request as a valid request. But remember, in Crown against Samuel, although legal advice was refused, right? But the accused himself said that I don't want. It wasn't refused. The accused himself stated in Crown against Samuel, I don't want legal advice because I know about the law. I've been coming in and out very frequently. So on the fact, is it an inductible offense? Yes. Police officer at least superintendent above? Yes. But what are the grounds? He said that, oh, you are coming in very frequently, so you know the law. Well, that cannot be the ground. The ground must be anything from here. So on the fact, I consider the refusal is unjustified and unlawful. If you want to get good marks, please discuss note B3 to code C. Where note B3 to code C very clearly stated, decision to delay access to solicitor is a rare occurrence. Very rare. Decision to delay access to solicitor is a rare occurrence. It's not something very common. Anybody have any issues? Can you see how many issues are being tested? We are nowhere end of this question, right? So don't think I'm doing less question because you can see how many issues are there. Right? See, after this, we have to look at hearsay, right? Then after hearsay, we have to look at bad character evidence. And after that, only this question is done. So there's so many issues to discuss, not one or two. Okay, the next part, hearsay. So the court stated, the question stated this. Adil will not appear at the trial as he has go to hospital for major operation. As you guys know, the question stated so. Adil will not appear at the trial as he has to go for a major operation. So, of course, Adil's statement, or whatever Donald told Adil, right? It will be adduced as hearsay. Can this be admitted? Or is this first hearsay? We have to discuss section 115. sub 3. Section 115 sub 3 of Criminal Justice Act 2003 stated, if the purpose or one of the purpose of the maker of the statement is to cause another person to believe the matter, then it is hearsay. And if it is hearsay, it is inadmissible. Right? I repeat, if the purpose or one of the purposes of the maker of the statement is to cause another person believe the matter, it will be hearsay. And if it is hearsay, it is inadmissible. So it was stated that one evening he overhears a conversation in the bar in which Boris tells Charlie, Donald has the best supply for cocaine. His phone number is this. Right? This is the hearsay statement. Boris tells this to Charlie. Donald overheard this. So, when Boris tells this to Charlie, is it his purpose or one of the purposes of Boris to make Charlie to believe whatever he said is true? Look at the statement. One evening, he overhears the conversation in which Boris tells Charlie, this is what Boris tells, Donald has the best supply for cocaine. His phone number is this. Do you think the purpose or one of the purpose is to cause you to believe? It's like, if I come and tell you, hey, the movie is very good, all right, you can watch, right, at the shopping complex nearby, right, in a theater. Is it your purpose or one of your purpose to cause me to believe the movie is good? Or is it your purpose is to share your excitement? Like when I come and tell you, oh, the drugs is so good. Okay, we don't go to drugs. When I come and tell you food is so good, go to this restaurant, super good food. You want to share your excitement or you want me to believe? I think it is cause you to believe. Okay. If you think it is cause you to believe, right? You can have a difference in opinion, no problem at all. But we must go on and look at the established case laws, right? What they said, right? So we can actually borrow some principles from there. You can see the case of Crown against Leonard, which is almost very similar to our question. This is actually a supply of drugs. So there were two text messages, right? Text message is already hearsay, right? So in one of the text message, this is what the buyer told the seller. Cheers for yesterday. But he put YD, right? So it's a short form. Well sound gear. You see that? Well sound gear. And in our question is, what is that? Our question is best supply for cocaine. Almost similar, right? Right? So this is the first text message. Well, feel Venkat today. What is some bad words? I actually put the exact text message. And I've actually put asterisk on all the bad words there. Right? But this is the real text message. Right? This is a real text message. The court stated, look at the first statement, well sound gear. The court stated this is expressing happiness. This is not to cause someone to believe the matter. Expressing happiness. Second one is a mark. That was a proper dog. There's a bad word. Move mate. That Joey was a 5 pounds Joey. I think Joey is cocaine, I think. And that was my last 10 pounds. Thanks. I don't know why I think you would not do that to me. I don't. This is the messages that you send to others when you are very high on drugs, right? Because when you read these messages, it doesn't even make sense at all, right? And the court stated, the second statement is to express unhappiness. The first statement is to express happiness. In both, the court stated, can you see? The court held that both statements have the purposes to cause someone to believe what was stated was true. So, well sound gear is actually a statement expressing happiness, and unhappiness is the second statement. And the court stated is to make someone to believe the matter, right? So, like what you told me, the court's judgment is almost the same. But if it is me, I would say that no. The reason is because why? Because if it is not a hearsay, it is admissible as direct evidence. It is showing here that my internet connection is unstable. Can you all hear me clearly? Are you hearing me clearly? Is this okay, or am I lagging or something? Or you are hearing me clearly? Just a pause before. So now is it okay? Okay, great. Thank you. So you can put this case, Crown against Leonard. You can put this case and you can say well sound gear. So you can say it's hearsay, no problem at all. Right? And Crown against Twist. Now, please don't discuss all the cases. I repeat, don't discuss all the cases. You discuss all the cases, I can swear to you, this will be the only question you discuss in the exam. Already, evidence questions are very long. Don't make your answer even more longer by discussing 1001 cases. One case is enough, right? Don't go more than one case, right? I am doing this as a revision, so I am, I'm supposed to explain this to you. Crown against Twist 2011. Right? The court stated text messages could be hearsay, right? Under Criminal Justice Act 2003, and therefore we have to go under some exception. And you see Birch and Hearst criticism. You know why I'm discussing criticism? Because the question stated, explain where the law is unsatisfactory. Right? So you have to explain where the law is unsatisfactory. So Birch and Hearst, evidence law textbook authors, stated that in the first case, right? They have criticism in regards to Leonard, 2009 case. They said this. In each case, the texter intended to cause Leonard to believe a matter that the gear was good or bad. No intention to assert the one matter for which pros sought to rely. L had supplied each with drugs. Do you know what they're trying to say? I just want to share my happiness to you. Like for an example, if I come to you and say that, no, I went to Mongkok and then there's this one food is super good, so nice, so tasty. And then if I come and tell you, I don't think so, I don't believe you. And you will come and tell me that, no, really, it's very good food. And then again, I told you, I don't think so. You don't bother. You will be thinking that you think so or what, I don't care, but the food was good. That is what Birch and Hearst trying to say. Birch and Hearst trying to say, the intention is, or the purpose is not to cause someone to believe the matter. The purpose is just to express happiness. Do you see that? So if you go to the second line, look at what he said. Texters operated on assumption that Leonard already knew that, so did not seek to cause, right? There's a typo here. Cause him to believe that matter. It's just an expression of happiness. Do you understand? Whichever you decide whether it's hearsay, you decide it's not hearsay, it's not a problem. But please put the criticism there. Anybody have any issues? Okay, so I'll give you a break now. Then after break, we will finish up Curly. Then we'll go to bad character evidence. We have another issue in regards to Curly here. Right, then we go to bad character evidence. Please take your break. Okay, I'm back. For those who just come very recently, this is actually the notes that I'm referring to. I've just uploaded. You will receive it again. Okay, so I've stopped at Birch and Hurst criticism just now. Now, right after the criticism, right now we have to continue with hearsay. So we have to go on and look at another area in regards to hearsay, which is in regards to implied hearsay or Crown against Curly type of a situation. Why I'm discussing this? Because Donald will say, just because my name and my phone number was mentioned, right? Because remember, when Boris was talking to Charles or something, Donald's name and phone number was mentioned. If you go to the beginning part of the question, see, Boris tells Charlie, Donald has the best supply for cocaine. His phone number is this. So what Donald will say now, Donald will say that just because my name and phone number is mentioned, it doesn't mean that I am the person, right or no? Anybody can actually mention my name. And this will trigger an issue in regards to Crown against Curly or implied hearsay. Right? Crown against Curly or implied hearsay. As you know, the facts of Crown against Curly is that, right, the police was inside Curly's house. Few people knocked the door and asked, where's the drugs? Few people call and ask, where's the drugs? Right? Where's Chibi? Chibi is actually Curly's nickname. But none of them say Curly is a drug dealer. They all ask like, where's my drugs? Right? Things like that. And Curly told the court that if they say it expressly, right, that Curly is a drug dealer, and police heard it, right, and come to court, then it will be an hearsay. And just because they said my name now, without saying my name, they said that I'm actually a drug dealer because they said that like, where's my drugs, where's my usual supply and things like that, that imply me as a drug dealer. So he said that it cannot be said expressly means it cannot be said impliedly. Right? So you must refer back to Subramaniam against DPP. Do you remember Subramaniam against DPP? Subramaniam against DPP is actually before Criminal Justice Act 2003. Subramaniam against DPP. And what was the definition of hearsay there? If you are proving the truth of the statement. If you are proving the truth of the statement, then it is hearsay. Right? And it is excluded. If you are proving the fact that it was made, proving the fact that it was made, not hearsay, admissible. In fact, this is what was being tested in Crown against Curly. Right? So, however, you must know, in the case of Crown against Curly, although the court allowed implied hearsay, but in the subsequent cases like Crown against Singh and Crown against Chrysostomo, the court very clearly stated the concept of implied hearsay is overruled. There is no implied hearsay any longer. Right? There's no implied hearsay. It's overruled. So, therefore, if you decided this is a hearsay, then under which section you can bring this? Section 116. Right? Please remember, section 116 is applicable here, and the factor will be the police or the spy don't want to come to court because of his mental or bodily injury, bodily condition. So section 116 of 2B factors are also satisfied. So hence it will be admissible under section 116. Anybody have any issues? Okay, no issues means now we have to look at bad character evidence. Right? Now, why we are looking at bad character evidence? Because you can see the question stated that Adil does some background checks. Adil is actually the spy police officer. Adil does some background checks and discovers that Donald has one past conviction for possession of marijuana, a Class C drug. Right? One previous conviction for possession of marijuana, a Class C drug, with an intent to supply from 1 year ago. The current offense is also in regards to drugs. So, the prosecution wants to definitely adduce this. And the prosecution will adduce this as an evidence to show propensity. Right? First of all, if prosecution wants to bring a bad character evidence, they will do this via section 101 sub 1D. Right? They will do it via section 101 sub 1D. And by following section 101 sub 1D, what is 101 sub 1D? We have looked at this yesterday. 101 sub 1D is important matters in issue between the prosecution and the defendant. So 101 sub 1D will redirect you to section 103 sub 1A, which is in regards to propensity to commit the offense. We want to adduce this offense to show that the defendant has the propensity or tendency, right, to commit the offense. And how do we prove that? Section 103 sub 2, which stated that offense of same description can be taken into account to prove propensity to commit the offense. Offense of same description can be taken into account. The last case was also drugs. The current case is also drugs. So definitely it shares the same description. Right? Definitely it shares the same description. And hence, most likely it will be admissible under section 101 sub 1D unless any exclusions are applicable, right? Which is under section 103 sub 3. Probably we can take this into account. The court may, by reason of length of time, exclude the evidence from being admissible if it results in unfairness. Right? And which evidence we are talking about here? The earlier evidence that I explained to you just now. See? From 1 year ago. Whenever the examiner indicated the time like that, it means they want you to discuss 103 sub 3. Because 103 sub 3 is in regards to by reason of length of time, probably the evidence can be excluded. Right? So the examiner's intention is they want students to discuss that. And so please discuss that. Whenever they say that from 5 years ago, from 2 years ago, from 6 months ago, they want you to discuss that. So since we decided that it can be admitted under section 101 sub 1D of Criminal Justice Act 2003, therefore Hansen direction must be given. This is the direction that we have looked at yesterday as well. Hansen direction is by following the case of Crown against Hansen 2005, which is one of the first cases that was not one of the first cases. It was the first case ever decided for bad character evidence under the new regime of Criminal Justice Act 2003. And what is the direction? Well, when I say direction, remember this. Please don't write in your exam that judge have to consider this. That answer is a wrong answer. It's not judge have to consider this. The judge have to direct with this direction to the jury. Do you understand? Jury have to consider this, not judge have to consider this. Right? I don't want you to go and write that the judge have to consider the following direction. That's wrong. The judge only give direction. Considering direction all is actually jury's work, not the judge's work. Hansen direction. Did the history of conviction establishes a propensity to commit the offense? Do you think a person who committed drugs related offense before would more likely commit drugs of related offenses now? And number 2, did the propensity make D more likely to commit the offense? If you think that any person who has been convicted of a drug related offense before will be committing this offense or more likely committing this offense, then do you think D will commit such an offense? Just now, anybody. Now D, defendant. And if the answer for that question is yes, do you think it is just to rely on the same description or category? Or would it be unfair if such evidence is admitted? All okay? Anybody have any question? Okay, now you go on and look at propensity to be untruthful. We did not look at this yesterday, but we have looked at this in lectures, of course. I think these lectures, we have just did this lectures, right? So for propensity to be untruthful, this is an option. I repeat again, this is an option. Why I call this as an option, right? It's because usually, right, if the examiner wants you to discuss propensity to be untruthful, they will put an offense like fraud. They will put an offense like deception offenses. They won't put drugs related. If you want to discuss this, you can. But usually if you get fraud, if you get theft, that's your previous conviction. If you get fraud, if you get theft, if you get deception offenses, you have to discuss propensity to be untruthful. So for propensity to be untruthful, we have two cases, right? And that is Crown against Campbell and Crown against Henson. Okay, that's a question. The conviction was 1 year ago, so it's not long enough. And so the court did not court did not exclude it under 103 sub 3. Well, if you ask me, well, it depends on the discretion of the court. But if you ask me, I would say 1 year ago, it's not really that long. So therefore, I don't think the court will exclude the evidence. Unless if the evidence is highly prejudicial. If it is highly prejudicial, then probably we'll exclude it under section 101 sub 3. Remember section 101 sub 3? Yesterday we have looked at this. Section 101 sub 3 is in regards to when there is a when the probative value of the evidence, when the prejudicial effect of the evidence outweigh the probative value, or when the adverse effect of the evidence, right, it's actually affecting the overall fairness. Same like section 78. Adverse effect to the fairness of the proceedings. So 1 year ago, I don't think so. All right. There's no hard and fast rule for such reasonable timing, right? We just use our own judgment. Yeah, definitely. But of course, you also see sometimes if they say 40 years before, then probably, 40 years before means I would say that probably the judge can exclude, right? Provided in that 40 years you are clean. You see, after that 40 years, in between you have all small offenses. 40 years before there was one rape. Then it's impossible, right? Okay, great. No problem. Okay, so evidence of propensity to be untruthful. You have two cases. Crown against Henson and Crown against Campbell. The Henson here is the same case Henson that we have looked at just now. But remember, the Henson here is in regards to propensity to be untruthful. So the direction is very different. So first of all, we'll go to Campbell. What Campbell stated. If you want to bring any section under 103 sub 1b, which is propensity to be untruthful, then number one, telling lies must be an element of the offense charge, the current offense. What offenses have telling lies as one of the elements? Fraud, deception offenses, perjury. That's all. Telling lies must be an element of the current offense charge. Fraud, deception offenses, perjury. And the previous offense, right? The previous offense must be an offense which element involves telling lies. Fraud and perjury. Fraud, perjury, and deception offenses. So you can only bring an evidence to show propensity to be untruthful of the defendant if the current offense involves telling lies and the previous offense also involves telling lies. Current offense must involve telling lies. The previous offense must also involve telling lies. Only then you can include this. You get this? So definitely, Henson is of no use to us. Because on the facts of our question, it's not fraud, it's not perjury, it's not deception offenses. And remember, you got to satisfy both. Not either one. You must satisfy both. Okay, this is test under Campbell. Test under Henson is In the present case, truthfulness must be an issue. That's number one. When truthfulness will be an issue? Whenever the defendant testified or adduce evidence via witness. Whenever the defendant testified or adduce evidence via witness, his truthfulness is always an issue. Whether he is telling the truth or not is always an issue. So on the facts, is the defendant is actually telling lies? Sorry, is the defendant is being testified? If you look at the facts, there's no particular indication, but we can presume this, no problem. In the earlier case, there must be either a plea of not guilty and the defendant gave an account on errors in interview on evidence which the jury disbelieved. That means in the previous offense, in the previous case, you pleaded not guilty. See, number one must be satisfied regardless of whatever reason. But in number two, you satisfy either Roman number 1 or Roman number 2 only. Right? Number 1 must be satisfied. In number 2, you satisfy Roman number 1 or Roman number 2, depends. So in the earlier case, plea of not guilty must be given. When you pleaded not guilty, but you still have been convicted, meaning the jury disbelieve you. The jury never trusts you. Right? Only in that possibility, you can say that I'm a liar. It can be for any offense. See, in number 1, it can be for any offense. Right? When you testify, when you put witness, adduce evidence via witness, your truthfulness is always an issue. In the earlier case, you pleaded not guilty, the jury disbelieve you, any case. Or the way in which the offense committed shows propensity, which is, as I told you, which is fraud, perjury, deception offenses. Do you get this? So on our facts, we don't know whether he's testifying or not. But in the previous case, we don't know whether he pleaded guilty or not. So we can't decide this on the facts. And obviously, the way in which the offense committed does not show propensity for untruthful, your previous offense. Right? Why? Because the previous offense was drugs. In drugs-related offenses, untruthfulness is not an element. Do you get this? We are done with this question. Anybody have any issues? So that's a very long question, right? You can see my outline itself is 8 pages for that question. Anybody have any issues? Okay. If no issues, then you see page number 9. Can you see page number 9? Question 6, 2022 Zone A. Right, let me look at this. Jennifer reports to the police that a few weeks earlier, her husband Kenneth physically assaulted her when they were having an argument and that she suffered serious injuries. She gives the police photographs of herself with a large bruises on her arms and back. Right? She says she did not go to the hospital or her doctor at that time because she was so afraid of her husband. When questioned by the police, Kenneth admits he shouted at Jennifer when he came across a large number of emails between Jennifer and her work colleagues. Larry, right? Work colleagues is Larry. That suggested to him that Jennifer had been having an affair with Larry, which Jennifer told him was entirely untrue. Right? So, it seems like the husband found out that some emails, but then the wife told him that it's entirely untrue. Right? However, Kenneth denies attacking Jennifer or causing her any physical harm. When shown Jennifer's photo of her injuries, he claims they are fake and says that Jennifer has always been a total liar and a fraudster. He says that she has concocted this whole story because she wants to run away with Larry. Right? Kenneth is charged with assaulting Jennifer, causing her grievous bodily harm. Kenneth is charged with assaulting Jennifer, causing her grievous bodily harm. At trial, he pleads not guilty. And in his testimony, will call on jury to believe in his innocence because he is a fervent Christian. That means you are an ardent Christian who has always upheld the highest standards of behavior and truth-telling. At trial, prosecution seeks to A, call Maria, an ex-girlfriend of Kenneth from 5 years ago, to testify that he was extremely jealous and hit her on a number of occasions when she thought she had been unfaithful. Maria will also say that she did not report these incidents because she was afraid of Kenneth. B, adduce evidence that 1 year ago, Kenneth was tried for assaulting another previous partner, Otholi, although he was found not guilty. Right? This is another evidence. 1 year ago, Kenneth tried to assault another previous partner, Otholi, although he was found not guilty. Then C, adduce evidence of violent pornography found on her hard drive, on the hard drive of Kenneth's computer by the police. D, adduce evidence that 20 years ago, Kenneth was convicted of fraud in relation to a false tax return and fined £1,000. E, adduce Jennifer's witness statement to the police because she says she is too afraid to testify against Kenneth in court. You see here, I'm still reading question, right? It's you must imagine how long is this question, right? It's not that short question. It's a bloody long question because I'm still reading question here, right? And I think it's already going to be like 3 minutes or something. In his defense, Kenneth will seek to call Finneloffi as an expert witness to say that the photos have been manipulated by putting Jennifer's head onto images available on the internet. Finneloffi has a degree in psychology and says she is highly competent in explaining the mindset of fraudsters. So there's some expert evidence issue there. Discuss the evidential issues arising. Adding critical comments where you think the law is unsatisfactory. So that's a combination of hearsay, expert evidence, and also there's a bad character evidence. There's quite a lot. Because bad character evidence alone, you can see A, B, C, D. Apart from that, here got some bad character evidence. Right? And apart from that, here got some hearsay. Here also got hearsay. And there's one expert evidence. And they stated it's not expected for answers to comment on admissibility of Jennifer's photos at trial. Assume they are admissible. Right? Because photo will cause a separate issue in regards to hearsay, whether photo is a hearsay or not. Right? So we don't want to get into this discussion. Thankfully, the examiner stated you don't have to discuss photos. This is stated by the examiner, not by me. Right? This is present in the question, the last 2 lines. Okay. So the answer guideline, we have to go one by one, right? And I'm going like part A, part B, right? But before that, I have discussed some bad character evidence on the first 2 paragraphs. Right? What is the bad character evidence in the first 2 paragraphs? If you can see here, Jennifer is the victim, right? And Larry is now telling that, so not Larry, Kenneth. Kenneth denies attacking Jennifer or causing her any physical harm. This is considered to be attacking another person's character. If you say, no, I did not do anything, that means you're implying that she's a liar. You're implying that she's a liar. Right? So if you imply that she's a liar, then that's an attack. Remember the case of Selvi against DPP? What the court stated? It is still considered to be an attack even though it is necessary part of your defense. So that's number 1. Right? Then number 2, when shown Jennifer's photos of her injuries, he claims they are fake. That's another attack. and says Jennifer has been always a total liar and fraudster. And he says that she has concocted this whole story because she wants to run away with Larry. This is another attack, right? So they can attack you back. Tit for tat rule. Under section 101 sub 1G of Criminal Justice Act 2003. Then he also said that he pleads not guilty. In his testimony, will call on the jury to believe in his innocence because he's a fervent Christian. When you say that you are a Christian, that is that is actually a 101 sub 1F issue. Section 101 sub 1F. Right? Section 101 sub 1F. False impression. So first we have to discuss these two things first before we go on and discuss others. So I've started off with section 101 sub 1G. And I've just told you that Kenneth attacked Jennifer. Please write down all the attacks to the examiner. Then you will tell the examiner that Crown against Singh, James Paul. Can you see Crown against Singh, James Paul? What the court stated. An attack is made for the purposes of this gateway, even though it is necessary part of the defendant's case. So you can say she is a liar, but although, you can say that's my defense, but that is still considered to be an attack. So what is an attack means? Section 101 sub 1G, which redirect you to section 106 sub 2, stated that evidence attacking the other person's character means evidence to the effect that the person, right, has committed an offense, where a different offense from the one with the charge or whatever, or has behaved or is disposed to behave in a reprehensible way. Having an affair, isn't that reprehensible way? Having an affair in many countries, offense, right? It's called adultery. Adultery is an offense, right? Adultery is an offense. So definitely it's a reprehensible way if you're having an affair. A reprehensible way means something that is not moral, right? That is called reprehensible. So therefore, any bad character evidence against, who's the husband's name? Kenneth, can be admitted under section 101 sub 1. And by following the case of Highton 2005, the court stated, once it is admitted under section 101 sub 1G, it can go towards propensity to commit the offense. It can also go towards propensity to be untruthful. Whatever we have learned just now, Campbell and Henson, is not applicable to section 101 sub 1G. That is only applicable to section 101 sub 1D. Any issues? Anybody have any issues? All okay? I think yesterday also I discussed the same, right? So hopefully you're okay with this, right? If you still have any question, you can ask me. Okay, now we will look at section 101 sub 1F. Why? Because he said that he is a fervent Christian, right? He said he's a fervent Christian. So when you say that you are a fervent Christian, hopefully it is true. Because if it is not true, then we can attack you back, right? Normally, this type of issue will trigger section 101 sub 1F, or what do we call as false impression, right? If you have given a false impression, I have the right to correct that. When I say I'm referring to prosecution. So by following section 101 sub 1F, which actually redirects you to section 105 of Criminal Justice Act 2003, 105 sub 1A said this, that the defendant gives false impression if he is responsible of making any express or implied assertion, which probably give the judge or jury a false or misleading impression about him. Right? You are responsible of giving false impression if you give any express or implied assertion, which give the jury any false or misleading impression about you. And that includes, by following 105 sub 5, conduct, appearance, and dress. So on the fact, when you say that I'm a fervent Christian, right? I think that is taken. That's a false impression. Well, I don't know whether it's a false impression or not because the question never stated so. But I'm trying to say if it is false, the prosecution can repair that if it is false. We have some cases on point. You can see Crown against Ferguson. Defendant testify his regular attendance at mass. He said that I always go to church. Then Crown against Baker, right? He said that 4 years he had been living an honest living. In all the situation, the court stated 101 sub 1F can be used. Anybody have any problem? Okay. If you have no problem, then we go to part A of the question. Right? We go to part A. Part A stated this. The prosecution wished to call Maria, an ex-girlfriend of Kenneth, from 5 years ago, to testify that he was extremely jealous and hit her on a number of occasions when he thought that she had been unfaithful. Maria will also say that she did not report these incidents because she was afraid of Kenneth. So Maria is actually a witness for prosecution. Prosecution wants to bring this evidence in to show that he has propensity to commit a similar type of an offense because he was violent to his ex-girlfriend and therefore more likely is violent to his current girlfriend as well. So first of all, we have to consider whether is this a bad character evidence. Now you may ask me why I never discussed section 98 in my last two discussion. Why I did not do so. Section 98 is a definition of bad character evidence. So some students may ask me, so why you didn't discuss this when you were discussing 101 sub 1G or 101 sub 1F? Well, it's purely a style. There's no reason for this. You want to discuss this under 101 sub 1G? You discuss that there. You want to discuss this here? You discuss this here. But I'll tell you why I discuss this here because we know what is the bad character evidence here, which is he was a person of an extreme jealousy and he was caught of assaulting his ex-girlfriend, right? But we don't know what was the bad character evidence in the last two issues. We don't know that. Do you understand? Okay. So, we go on and write section 98, right? Definition of bad character evidence. What section 98 stated? Bad character evidence means misconduct. And what is misconduct? Has been defined under section 112. Section 112 of CJA 2003 stated misconduct means, right, commission of an offense or other reprehensible behavior. So on the fact, she did not even report that incident. So it cannot be a commission of an offense. It must be a reprehensible behavior, right? It must be a reprehensible behavior. And therefore, it is taken as a bad character evidence. And I would say the prosecution wants to adduce this under section 101 sub 1D, which is important matters in issue between the prosecution and the defendant. Important matters in issue between the prosecution and the defendant. And again, I want to adduce this under section 103 sub 1A, which is propensity to commit the offense. And how can you adduce this? You can go under either offense with same description with the one he's charged. But in the previous offense, it wasn't even an offense. It was a reprehensible behavior, right? They say that you can take offense of same description, but last time, the last offense was not even an offense. It was a reprehensible behavior. So how do you bring this in? Some people will say same category. No, it's not even an offense. That's why you have to go under number 3. Without prejudice to any other way of doing so. That means normally we will take into account of same description or same category, but you can also do it in a different way. That is, you take into account of reprehensible behavior. Do you understand this? Anybody have any issues? So, therefore, I said that we can bring this in under propensity to commit the offense. And please put section 103 sub 1A. Please put Hansen direction then. Right? The 3 direction, you must write it down to the examiner. Anybody have any problem? Anybody have any problem in Henson direction? All okay? Okay. So what I will do now, we go to part B. In part B, it was stated, the prosecution wished to adduce evidence that 1 year ago, Kenneth was tried for assaulting another previous partner, Ottoli, although he was found not guilty. Right? But he was actually, tried for assaulting another previous partner called Ottoli, although he was not guilty. So again, it was like a reprehensible behavior. So again, you will put section 103 sub 1A to the examiner, and you will say that we can bring this in to prove propensity to commit the crime. Do you understand this? Right? Even if he is acquitted, because the question stated, Kenneth was tried, but was found not guilty. Even if he was acquitted, it can be a reprehensible behavior. Because why not everybody being acquitted? Why only you? I mean, why not everybody being accused? Why only you being accused? Do you get this? So again, we will bring this under same description, same category, or without prejudice to any other way of doing so. And therefore, we can take this in to establish propensity to commit the offense, and Henson direction must be given. Any issues? Anybody have any issues? Okay. So if no issues, let me go to part C. Can you see part C? Look at part C. Where it was stated that prosecution wished to adduce evidence of violent pornography found on the hard drive of Kenneth's computer by police. Now, obviously, prosecution wants to bring this in to show that a person in whose computer there are a lot of violent pornography must be a violent man. Right? Must be a violent man. And therefore, again, you will tell the examiner, this is a reprehensible behavior. Right? This is not a previous commission of an offense. This is a reprehensible behavior. And therefore, we will actually bring this under section 101 sub 1D. The important matters in issue between the defendant and the prosecution. We will bring this under section 101 sub 1D again. Now, one thing that I must tell you, sometimes when students see that how come part A, part B, part C testing everything the same, oh, I must be wrong. You must have the guts, right, to tell the examiner you are testing as to everything the same. You must have the guts. Right? If they are testing the same, you must tell the examiner you are testing the same. You must have that guts to tell this to the examiner. Do you understand this? So this is propensity to commit the offense, and therefore you have to give Henson direction. The Henson direction is here. Any issues? Anybody have any issues? Anybody wants to ask me anything? That's great. We go to part D now. The prosecution wished to adduce evidence that 20 years ago, look at that line, 20 years ago, Kenneth was convicted of fraud in relation to false tax return and fined £1,000. See, whenever you see fraud, just now I told you, if the examiner wants you to discuss propensity to be untruthful, right? If the examiner wants you to discuss propensity to be untruthful, then obviously they will put fraud in. So This one we will not adduce as a propensity to commit the offense, but this one we will adduce as a propensity to be untruthful. Right? So you'll tell the examiner, we may have to adduce this as a propensity to be untruthful, and therefore you have to go on and look at the test of Campbell. What Campbell stated? Telling lies must be an element of the offense charge. What is the offense charge now? Assault. Does telling lies is an element of assault? What is the element of assault? Apprehension of unlawful something. Unlawful violence or something. Right? From your criminal law, this one. Right? But if you don't know, so it's not really a problem, but I'm just telling. Yeah. Apprehension of application of unlawful physical violence. That is called assault. Right? So, that's the element. Telling lies is an element of it. No. And in the earlier case, sorry, here, right? I went to Hansen accidentally. Previous offense must be an offense which element involved telling lies. Yes, previous offense is fraud here, right? Our previous offense is fraud. But the current offense, it does not involve telling lies, meaning you cannot apply Campbell here, right? You cannot apply Campbell here. And now you have to go to Hansen. Go to Hansen. Test under Hansen. In the present case, truthfulness must be an issue. Is he testifying? Well, he did not testify at trial, but he testified at police station. Right? He said that, she's a liar, this and that. That's enough. You did testify. And in the previous offense, plea of not guilty was given, jury disbelieve you. I don't know for the fraud trial, plea of not guilty was given or not. Or the way in which the offense was committed shows propensity. And fraud can be taken into account under Roman number 2. So this one satisfy, and this one satisfy. Therefore, under Hansen, you can bring this in. Under Hansen, you can bring this in. Do you understand? However, sorry. However, please remember that the offense was committed 20 years ago. The offense was committed 20 years ago. Meaning, by reason of length of time, you may probably try to exclude it. For lies, okay, there's a question here. For lies, is it we also use Lucas direction, not only Campbell? Might be I mixed them. Please advise. No. You see, Campbell is bad character evidence. But if you lie, that is Lucas direction. Lie means you are lying in the court or you are lying at the police station for the current offense. Lucas direction is given if you are lying at the police station or court for the current offense. But bad character evidence is for the previous offense. So you cannot give a Lucas direction for the previous offense because the previous offense is actually done and dusted. Do you understand the difference? Thank God you asked this question. Lucas direction is for lies. Lucas direction that I've looked at yesterday is for lies, right? For that was committed for the current offense. Lies that was actually made for the current offense. Previous offense is bad character evidence. That's why you have to go for Campbell and Hansen. Do you understand? Okay, great. So, what I was discussing, yes, 20 years ago, right? I told you this, whenever they put 20 years ago, 5 years ago, 1 year ago, 6 months ago, 17 years ago, you have to discuss section 103 sub 3. Now, I would like to give you a word of caution here, right? Remember this. Section 101 sub 3, which is, section 101 sub 3, which is adverse effect to the fairness of the trial. Adverse effect to the fairness of the proceedings. And section 103 sub 3, which is length of time. Right? These two exclusionary sections can only be used for section 101 sub 1D or section 101 sub 1G. You cannot use this length of time for any other sections. I repeat, 101 sub 3 and 103 sub 3 can only be used for 101 sub 1 or 101 sub 1G. What is 101 sub 1D? Important matters in issue between the defendant and the prosecution. What is 101 sub 1G? G, attack. We have just looked at this one. Attack. Attack on another person's character. Okay. Any issues? Don't apply this wrongly here. You are wrong if you do this. You cannot say that, by drawing an analogy, you can't do that. Because the section itself very clearly stated. Section 101 very clearly stated. 101 sub 3 and 101 sub 3 and 103 sub 3 only applicable for 101 sub 1D and 101 sub 1G only. No drawing analogy, right? No need to draw analogy, right? Please remember that. Okay. Now we go to part E, which is the final part, which is hearsay, as I told you. The question stated this. The prosecution wished to adduce evidence. Jennifer's witness statement. Jennifer's the wife, right? The husband assaulted Jennifer, right? To adduce Jennifer's witness statement to the police because she says she's too afraid to testify against Kenneth in court. So out of fear, she don't want to come to court. That's out of fear. And if it is out of fear, then it is a little bit problematic. So obviously, Jennifer is the victim. And Jennifer writing this down and whatever she has written down is now coming to court. So that's definitely hearsay because you have written it down. Your paper statement is definitely hearsay. So by following section 115 sub 3A, the purpose or one of the purpose of the maker of the statement is to cause someone to believe the matter, definitely. And under which section we can reduce this? 116 sub 2E, fear. Some students always ask me, so why you never discuss 116 sub 1A, which is, remember like yesterday I taught you this? If the maker of the statement comes to court, the statement must be admissible. And 116 sub 1B, which is the court must know the identity of the maker of the statement. Why I never discuss all these things here? Because we have no problem in regards to that. Why we have to discuss? The question is very long. So you cannot be like keep assuming things and discuss on your own. Am I right? Right? So if it is not really necessary, don't discuss that. Not necessary, don't discuss. So why she don't want to come to court? Out of fear. Right? And fear is a factor under 116 sub 2E. But unlike other factors, fear is a little bit different. You must obtain leave from the court. Right? You must obtain leave from the court. You have to write this to the examiner. Leave means permission. You must obtain leave from the court. And 116 sub 3. Fear has to be widely construed. Includes fear of the death or injury of another person or financial loss. So of course, she may be like fear for her personal safety or whatsoever. Right? So definitely that's part of fear. But when you go on and obtain leave or obtain permission, the court will take into account of this. The content of the statement, what she has written, any risks that its admission or exclusion may lead to unfairness. If you admit, what will happen? If you exclude, what will happen? How difficult to challenge the statement? These are all written under 116 sub 4. Right? What I'm discussing is a statute. What I'm discussing is a section. It's a statute. right? And any other relevant circumstances. Well, we don't get much factors there. So we cannot discuss this in detail. However, whenever fear is being asked in exam, you have to discuss the case of Crown against Horncastle. You know, the full name of the case is Horncastle and Marquis, right? Horncastle and Marquis. The current judgment that we follow when it comes to hearsay and human rights is the case of Al-Khawaja and Al-Tahiri against UK, right? Or they fondly call this case as Al-Khawaja against UK, which is a 2013 European Court of Human Rights Grand Chambers judgment. But we don't have to go to that now because we don't have an issue in regards to hearsay and human rights so much here. We do have, but it's less. See, the problem here is one of the factor that the court will take into account is this: how difficult to challenge the statement if the relevant person does not give oral evidence. Can I challenge this statement if she does not give evidence? Maybe very difficult because I cannot cross-examine a paper, right? Because she has given a paper and then she said that, you know, I cannot come to court out of fear. See, if you die, or if you got insane, or if you're injured, or if you're outside of UK, or if we don't know where you, then at least I can understand. But if you come and tell me that fear, that means you are there. You are there, but you don't want to come. By following Article 6 sub 3D, by following Article 6 sub 3D, right, of ECHR, the defendant has the right to examine the witness, to examine or cross-examine, right, to cross-examine the victim or the witness. But you don't want to come to court. So my rights also infringe. So that's what happened in the case of Crown against Horncastle and Marquis, right? That's the real name of the case. So in this case, in Horncastle, the victim died. In Marquis, the victim don't want to come to court out of fear, right? Now, the thing is, in both cases, there's a witness statement, right? Victim statement. And then after that, one victim die, one victim don't want to come to court out of fear. In both cases, the hearsay evidence that the victim or witness have written goes towards a decisive extent in securing the conviction, right? Goes towards a decisive extent in securing the conviction. And there was this test that was used by ECHR court in Al-Khawaja and Al-Tahiri, 2009. This is not 2013 judgment. This is 2009 judgment, where ECHR court stated any hearsay evidence that goes to the sole or decisive extent must be excluded, right? Any evidence that goes towards a sole or decisive extent to secure a conviction must be excluded. Now, in Horncastle, the court have actually rejected this ECHR view. The court stated in the entire, right, Criminal Justice Act 2003, we have a lot of safeguards. Even if you go to 116 just now, we have definition of fear. What is fear? We also have 116 of 4, right, which is in regards to when you can obtain leave, right? When you can obtain leave. We also have that. So the court stated, technically speaking, if someone don't want to come to court out of fear, and if defendant is the reason that the person is being feared about, then the defendant cannot complain. His Article 6 of 3D rights are infringed. What is Article 6 of 3D rights? Right to cross-examine the victim or witness. So if the fear is induced by you, you cannot come to court and complain to me that, you know, he don't want to come to court out of fear, but, you know, my right to cross-examination under Article 6 of 3D is infringed. You can't say that. And now this view by the court is approved, right? You can also write this down to the examiner. This view by the court is approved in Al-Khawaja 2013, Grand Chamber of ECHR. Grand Chamber Court of ECHR approve whatever stated by Hardcastle. So, if we get evidence that the fear was induced by Kenneth, then the evidence cannot be, I mean, you cannot argue that there's a breach of Article 6 sub 3D. Do you understand? Anybody have any problem? All okay? Okay, now we go to expert evidence. Can you see expert evidence? Now, on the facts of the case, there's one expert evidence, right? Apparently, it was stated that Kenneth will seek to call Penelope as an expert witness to say that the photos have been manipulated by putting Jennifer's hate onto images available on the internet. Penelope has a degree in psychology and says she's highly competent in explaining the mindset of fraudsters. That's expertise. Degree in psychology, and she's highly competent in explaining the mindset of fraudsters. And she came in. She came in to say that the photos have been manipulated. Well, what I told you yesterday while I was discussing expert evidence with you, first of all, there must be a need for expert evidence. Is there a need? We have to consider. When there will be a need, when the judge or jury cannot understand a particular evidence in that case, so we need expert evidence. And then second, the witness must be suitably qualified. Right? If you never satisfy these two things, right? I write it here. Need. That's number one. Remember, we have looked at this yesterday. With the expert must be suitably qualified. Okay. So please remember this. On the facts, we have to see, is there a need? If you want to come to court and say that this picture have been doctored, probably yes, there's a need, right? But then what's her qualification? See, not only she must be qualified, she must be suitably qualified. She's coming to court to say that this photo have been manipulated. Okay. Probably you need some designer to come and say this. But then she has a degree in psychology. And then she's highly competent in explaining the mindset of fraudsters. What does mindset of fraudsters has to do with the picture? Nothing also. So I said on the facts, she's not a photo alternation expert. I don't think that she is qualified. So I said that I don't think her evidence will be admitted. Do you understand? Done. Anybody have any problem? Anybody wants to ask anything? Yes, sorry, I understand the point on qualification. But how about the need point here on this facts? Need definitely. You know, like what I told you just now, need definitely, because the photo is being altered. Right? So, you know, sometimes a very good expert, I mean, nowadays we have AI to do that. Right? So it's very difficult for us, the non-technical people like us, unless you are one, unless you know you are in the industry, to know which is a doctored picture, which is actually a real picture. So the need is there. I would consider the need is there. You can disagree with me, all right? But I would consider the need is there. But I would say that she is not qualified. She's not qualified to do this. Do you understand? Anybody have any issues? All okay? What is the general principle for need? Okay, general principle for need is there's no hard and fast rule, but the rule is like this. If the judge and jury can understand the evidence on the facts, you don't need expert evidence. If the judge or jury can understand the evidence on the facts. So normally, like if you are bringing a biotech evidence or DNA evidence, the judge or jury cannot understand because most of us, unless you are from medical field, most of us are not really from medical field. We don't know what is this DNA evidence, how does this works, right? What is this DNA? They say that there's X, Y and all. We don't know. So this someone called an expert will come to court and tell the judge. But on something that, like for an example, on something that we already know. Like for an example, let's say, if a lady has been raped, right? And an expert evidence coming to court saying that judge, she was raped. She is very distressful, judge. She's having post-traumatic stress syndrome. Do you need an expert to come and say this? Everybody knows someone who has been raped will be in distress. Everybody knows someone who was raped will experience post-traumatic stress syndrome. You don't need an expert to come and say she's very sad, judge. Or who will be happy when they got raped? Would you be happy when you are raped? Would you say that, today is the day that, I got raped? I'm very happy. No, obviously no. So you don't need an expert evidence to come to court to say that. So remember, the need will arise when the matter is beyond the understanding of the judge or jury. You have some judges whose previous degree is in IT. So they will say that I don't need expert evidence. I look at the picture, I know whether it's doctor or not. They don't need expert evidence. For expert evidence, permission must be obtained. The judge must say, I don't understand, and therefore please bring expert. Only then you can bring. Any issues? You all understand? Okay, great. Okay, I'll give you a break now. Then after the break, we will look at a few more questions. Okay, I'm back. Okay, we are going to look at the other bundle that I've given to you. Just give me a second. I'll go and download this. Okay, in your evidence notes that I've given, evidence revision outlines, can you download this question 5 2018 Zone A? The title of the document is question 5 2018 Zone A. That's the title of the document. Okay. So let me read the question. This 2018 question, right? And if you go down in that outline, there are quite a lot of outlines. So you can see 2020 outlines as well in page number 6, right? And as you go down, another 2020 question. There's also, yeah, another essay question. This bundle has a lot of essay questions, right? Okay, so let me look at question 5, 2018 Zone A in page number 1 of this document titled question 5, 2018 Zone A. Okay, let me read. Jack is killed when a bomb placed under the driving seat of his car goes off. Alerted by the sound of the bomb, the police arrive and they find Amal hiding in some nearby bushes. Right, so Jack is killed. His bomb underneath his car, I think, under the driving seat, went off. Then police came and they find Amal hiding in some nearby bushes, right? The police arrest Amal. Arriving at the police station at 6 p.m., Amal requests a solicitor, but Inspector Brian refuses on the ground that given where we found you, I think you should just admit it was you who killed Jack, don't you? Amal makes no comment to all questions put to him in interview. This is the first part. Seems like by now you must be familiar with this. Seems like there's actually a refusal of legal advice here. Section 58. The police put him in a cell overnight, offering him nothing to eat or drink. In the morning at 7 a.m. So look at that. Police put him in a cell overnight, offering him nothing to eat or drink, which may be a violation of Code C, right? In the morning at 7 a.m., PC Hogan calls him for a second interview, still without a lawyer. PC Hogan questions Amal for 6 hours. After 2 hours, PC Hogan begins to shout and swear at Amal. These are all procedural irregularities. Can be Code C or 76 sub 2A or 76 sub 2B. Right, PC Hogan begins to shout and swear at Amal, calling him, "You smelly silent murderer," and telling him that no court in this country will believe a filthy foreigner like you. Right, so this can be Code C violation 76 sub 2A, 76 sub 2B as well. PC Drida then takes over from PC Hogan. PC means police constable, and tells Amal that if he confesses, he will make sure that Amal is released on bail and will be able to find his own lawyer. He also promises, so you see here, there's actually a thought here that if you confess, I will release you, you can find your own lawyer. So that can be 76 sub 2B, something said or done, and it comes externally as well. He also promises Amal that he will put in good word with the judge on his behalf. Amal confesses to the offense. Amal is charged with murder. At trial, the prosecution seeks to call expert witness to testify that an ear print found on Jack's car is a good match to Amal's ear. It's like an expert evidence on ear print. So that's expert evidence issue. The defense objects to admitting the expert witness on the basis that the field of evidence ear printing is not sufficiently reliable. Right? So there's no well-established expertise on that. Right? The defense also seeks to have Amal confession evidence excluded. At trial, Amal will explain that he hid in the bushes after the explosion because he was terrified. So he's offering an innocent explanation. Right? He said that I was terrified, that's a reason, which is logical as well. Discuss the evidential issues arising. including whether the defense would succeed in making submission of no case to answer. So, it's the first time you are looking at submission of no case to answer being asked in a problem solving question. Right? Ideally, you should know submission of no case to answer. I've looked at this while I was looking at lectures with you. If you go back to my lectures video, bad character evidence lectures video, I think on my third and final day, last day, while I was discussing DNA evidence, right after that, I have discussed submission of no case to answer. Right? The case of Crown against Hunter, Nigel, the case of AB against CPS 2017. Submission of no case to answer today is something that everybody should know because it's coming up, crossing frequently. Okay, so we start from refusal of legal advice. Right? For refusal of legal advice, the question stated Amal requests for a solicitor, but Inspector Brian refuses because he said that given where we found you, I think that you should just admit it was you who killed Jack. Don't you? So you put the two cases that I've taught you. Crown against Aladis. Aladis stated that legal advice is an inalienable right. Crown against Samuel, which stated that if the accused himself don't want expert evidence, we can dispense with that, provided he knows what he's doing. But on the facts, Amal requested for solicitor and it was refused. So we have to discuss Section 58 here. Section 58 of Police and Criminal Evidence Act 1984, where it was stated that if you want to refuse legal advice, then it must be an inductable offense. Is it an inductable offense? Murder is definitely an inductable offense. The police officer, superintendent above authorize it. On the facts, who is the police officer? PC, police constable. Police constable is not a superintendent. And you must have reasonable grounds. The grounds has not been stated clearly as well. All right, they just say given where we found you, blah, blah, blah. That's all. So on the facts, the refusal may not be valid. Right, but please do remember and keep reminding you again and again, when you discuss Section 58, please mention the same thing has been mentioned under Annex B, Code C. Please do that. If you want, you can even put Code C, Code number 6. That I just asked you to take note. Code C, Code number 6. Annex B is, you can go to Annex B and see. Annex B is under Code C. They have discussed the same thing. Okay, so now we go under confession. The question stated that Amal has actually confessed to the crime. Right? Now, if Amal confessed to the crime, it can be still excluded. And for the exclusion, obviously, defense wants to go on and look at exclusion. So we want to go on and look at Section 76 sub 1 first. 76 sub 1 stated, if you want to exclude an evidence or any, sorry, if you don't, not really excluding, so Section 76 stated, any confession statement is admissible provided it is relevant and should not be excluded under 76 sub 2A and 76 sub 2B or 76 sub 2B. Now, please remember here, I've only put here 76 sub 2B, but you have to add 76 sub 2A here as well. All right, it should not have been excluded under 76 sub 2A or 76 sub 2B or both. Okay. So on the fact, we are going to put oppression here. Again, as usual, 76 sub 8. What is the definition of oppression? Torture, inhuman or degrading treatment, and the use or threat of violence, whether or not amounting to torture. If you don't want to discuss that, you can also discuss the common law definition under the case of Crown against Fulling, 1987. So what happened on the facts? Is there an oppression? You can see here. The police put him in a cell overnight, offering him nothing to eat or drink. Isn't that considered to be an oppression? Yes. After 2 hours, PC Hogan begins to shout and swear at Amal and said that you smelly silent murderer, telling him that no court in this country will believe a filthy foreigner like you. It's all like bad words, derogatory words being thrown. Do you get this? Anybody have any issues? Okay. So on the fact, most likely there will be an oppression. Then followed by 76 sub 2b. Right? Section 76 sub 2b. Something said or done. Again, you have to go on and include the case of Crown against Goldenberg. Right? As you know, in the case of Crown against Goldenberg, the court stated something said or done must come externally. On the fact, something said or done, has it come externally? Yes. Because you can see, right, in page number 3, PC Drida. PC Drida tells Amal, if he confesses, he will make sure Amal is released on bail and will be able to find his own lawyer. Isn't that something comes externally? And PC Drida also promises Amal that he will put in a good word with the judge on his behalf. So that's also something said or done. You understand? Then followed by the 3 requirements. I write it back. Number 1, something said or done must come externally. Number 2, causation. Number 3, reliability. Right? I mean, unreliability. Must write these 3 things, huh? I'm not writing this for fun, you know. You must write these 3 things to the examiner. Right? 3 requirements under section 76 sub 2b. All requirements must be satisfied. Right? Not either one of it. I repeat, not either one of it. All requirements must be satisfied. Something said or done must come externally. Causation principle must be satisfied. And unreliability must be satisfied. Okay. If you want examples, the perfect apt example is Crown against Paris, 1992. Right? Crown against Paris, 1992. Which actually in regards to, you know, remember I just told you, Crown against Paris, Miller, Abdullahi. Right? Crown against Paris, Miller, Abdullahi. And in Crown against Paris, Miller, Abdullahi, what has happened? Remember I told you, the same question was repeated 300 times. Right? Did you do this? Yes. No. Did you do this? No. Did you do this? No. And then finally, one time he said yes. They said that that's a confession. So most likely I would say under 76 sub 2b, the confession will be excluded. Even under 2a, it will be excluded as well. Then the next stage is confession under excluding confession under 78 and 82 sub 3. 78 is under Police and Criminal Evidence Act 1984, where adverse effect, there is an adverse effect to the fairness of the proceedings. Right? And 82 sub 3 is in regards to when the prejudicial effect of the evidence outweigh the probative value. When the prejudicial effect of the evidence outweigh the probative value. Okay. So that's 78. And I haven't discussed 78. I'm just telling you what is 78. Then 82 sub 3, I just told you. And what are the Code C breaches here? Code C breaches here. This one. At least 3 meals, para 8.6. At least 3 meals, right, should be provided, should be offered within any 24 hours period. But they did not do so. Para 10.1, suspect must be cautioned. Do you know what is cautioning means? Cautioning means when you arrest someone, you must say, sir, you are under arrest. You are not obliged to say anything to me. You have the right to remain silent. But if you remain silent on whatever expected from you reasonably, then adverse inferences can be drawn against you. You get this? Okay. Para 12.8, breaks at recognized meal time and short refreshment breaks at interval of 2 hours. If you look at the question, what has happened? you look at the question, he also promises Amal that he will put in a good word with the judge on his behalf. As this, sorry. I think above. Here, see, second paragraph, first line. The police put him in cell overnight, offering him nothing to eat or drink. There's a procedural irregularity. PC Hogan, question Amal for 6 hours. Blah, blah, blah. Everything is there. Right? So, these are all procedural irregularity. Do you understand? Anybody have any question? So please do write Crown against Keenan. Crown against Kennelly. Only a significant and substantial breach will be excluded. Only a flagrant, deliberate, cynical breach will be excluded. One breach does not warrant an exclusion. A collection of breaches will warrant an exclusion. All okay? Okay. So we go to now submission of no case to answer. The question stated that the defense wants to give a submission of no case to answer. So what is submission of no case to answer? You guys still remember from the lectures? If you don't remember, no problem. I'll explain this back. See, in any criminal trial, prosecution will start first. Because, as you know, even from your criminal law, you studied this. Even in your burden of proof in your third year evidence, you studied this. That is, Lord Justice Viscount Sankey in the case of Woolmington against DPP stated what? In any criminal cases, the prosecution bears the burden of proving the case beyond reasonable doubt. Legal burden beyond reasonable doubt. So therefore, in every trial, the prosecution will start first. Prosecution have to prove AR. Prosecution have to prove MR. Once the prosecution have proven AR and MR beyond reasonable doubt, a prima facie case is established. So what the court will do? The court will ask the defendant to enter defense. And when the defendant is supposed to enter defense, why he's entering defense? Because prima facie case is established. So when the defendant is entering a defense, instead of entering a defense, the defendant will say, no case to answer. And why there's no case to answer? Because he will look at the judge and he will say that it's because the prosecution never managed to prove the case entirely. So you'll be like, what do you mean? Right? So you'll probably say that there's some element have not been established. So when you get a submission of no case to answer, how do you suppose to handle it? Remember, if the defendant obtain a submission of no case to answer, if it is successful, it will lead to a full acquittal. Full acquittal, you know, right? So it's very much beneficial to him. First, you go to the case of Crown against Galbraith, 1981. You have to write exactly whatever I've written here, but you must modify and write a bit. Right? You understand, right? Don't exactly copy here. Right? Paraphrase. Write in your own words. Because you know plagiarism. Right? We don't want that. So please write in your own words. Read this. I assume that you guys will print these notes and bring for your exam. Right? Because it's an open book exam. But paraphrase and write. Don't write entirely. Don't write word by word. Because it will lead to plagiarism. Okay. So Crown against Galbraith, 1981. Lord Lane, LCJ. Lord Chief Justice. He said this. How do we approach a submission of no case to answer? He said, number one, if there's no evidence at all, then stop the case. Done. Super easy. Right? If you think that there's no case, no evidence, there's no evidence, stop the case, no problem. But often this won't happen because prosecution is not a fool. Right? There will be always evidence. The problem is the evidence maybe sometimes tenuous, meaning weak. So if it is weak, then what you're supposed to do? I mean, there's an evidence, but the evidence is weak. So if it is weak, what we will do? There are two things. If the judge decided that based on the evidence, the judge can properly direct the jury, right? Sorry, if the judge the judge properly can direct the jury, but the jury cannot convict based on the evidence because the evidence is very weak. I repeat again, if the judge decided the weak evidence, right? If I direct the jury will find it difficult to decide the case, to deliver the verdict. Then you must stop the case. But if let's say, the strength and the weakness of the evidence, it depends on the witness reliability. The strength and the weakness of the evidence, it depends on the reliability of the witness. Then you don't have to stop the case. You can leave the case to the judge. So if you want me to summarize this, number one, no evidence, stop the case. Number two, weak evidence. If it is weak evidence, Roman number one, right? Whether after directing the jury, the judge is of an opinion that the jury may not able to deliver the verdict. If this is the case, stop the case. But if the strength or weakness of the evidence depends on the witness, right? Then don't stop the case. This is how you have to write to the examiner. This is what exactly how you're supposed to write to the examiner. You don't have to write entirely like that. You write like this, you are done. More than enough. Anybody have any question here? So I'm going to explain now. No evidence, everybody knows. Weak evidence, the judge cannot properly convict. Right? Like for an example, we only have confession. We don't have any other evidence. Right? And the confession is now excluded. Right? And okay, let's say there are two evidence. One is confession. Confession is excluded. Right? Another one is, let's say, evidence in regards to hearsay. Hearsay is a weak evidence. Right or no? So if you think that based on this, the jury may not able to deliver verdict because they will feel confused, stop the case. Give the benefit of the doubt to the defendant. But if you think that there are evidence, but the evidence, the strength or weakness of the evidence depends on the witness, right? Depends on the witness credibility. Then leave the case, let them to decide. The principles you just stated are from Galbraith, right? Yes, that's right. Galbraith. Right? That I've written here. Crown against Galbraith. Anybody have any issues? All okay? So merely writing this is not enough. Right? Because you have to associate it to the facts. And you must say whether submission of no case to answer here may be possible based on the case of Galbraith. So on the fact, if you look at the evidence, there's confession but it's tainted. We don't know whether it's excluded or not, but it's tainted. Tainted means it's not really proper because a lot of procedural irregularities. There's also no other evidence. Right? No other evidence. That's the only evidence. So I say that most likely submission of no case to answer will be successful here. Any issues? Anybody have any issues? Okay, I repeat again here. Merely discussing Galbraith is not enough. You must discuss AB against CPS 2017. Right? I repeat, merely discussing about the case of, what case was that? The case of Galbraith. That's not enough. You must discuss AB against CPS. Right? So look at AB against CPS. Can you see AB against CPS? So what happened was this. The victim's laptop, right, was actually stolen. And the victim described the assailant, the person who actually stole the laptop, as a white, age between 20 and 26, wearing black and white tracksuit, hat and gloves. This is from identification evidence. Right? This is from identification evidence. So the police went and arrested someone around the crime scene. And that person was 16 years old. But what the victim said just now, 20 to 26. The victim said he's actually a white, but here it's a mixed African Caribbean. And he's wearing a dark clothing here. And the victim also said that they're wearing a black and white tracksuit. White is not dark, right? With a hood and face mask. And apparently the victim say hat and gloves. A lot of IDs are not matching. But the laptop bag was found at his home of the accused at his brother's room. Laptop wasn't found, but laptop's bag was found. In trial, right, the defendant gave a no comment. Right, he said that I don't know anything, no comment interview, and he submitted for no case to answer. Right, he said no comment interview. He submitted for no case to answer, and magistrate refused that. So it went to appeal, and in appeal, the court stated this: magistrate had failed correctly to apply Galbraith's test, and submission should have succeeded on the second limb. The evidence taken as IS was such that no reasonable jury properly directed could convict. Why? You look at ID. How many IDs are not matching? Right? Here is age between 20 to 26, wearing black and white tracksuit and gloves. And then there 16, mixed African Caribbean, wearing dark clothing with a hood and face mask. Doesn't make sense. Do you understand? This is what we call a jury, even properly directed, cannot reach the decision. Anybody have any issues? So, on the fact, submission of no case to answer here. Is that possible after you look at AB against CPS? Still yes, because we have decided so. Any issues? It's a third question, right? Yeah, third question that I've looked at for today, right? Okay, you go to page number 6, the next question. For no comment to all question in first interview, do we need to discuss right to silence? If it is a normal question, no comment to all question means it is actually a right to silence issue. But on our facts, we don't have no comment. Right? The case AB against CPS, there was a no comment thing. On our facts, there was no comment. Right? The no comment doesn't exist, I think. Was there a no comment there? To clarify one point, yes. What is the question is about? Now, while waiting for the question, I hope you can identify the issues quickly after this. because we have looked at not one. Yesterday 4 questions, today is now, this is the 4th question, 8 questions ready. Okay, there's a question. Here we discuss no case to answer because the question category asks us. But normally we don't discuss, right? No. In any no case to answer, the examiner will tell you the defendant is submitting no case to answer, please discuss. You will always get indication for no case to answer, because if you never write, I don't know. I don't know why the defendant, I don't know whether the defendant going for no case to answer or not. So if it is not discussed, if it is not stated, you don't have to discuss that. Please remember that. Right? If it is not stated, you don't have to discuss that. Right? You will always get an indication, submission of no case to answer. Yes, yeah, definitely. This is crucial. So yeah, on that line, I want to tell this. Evidence law questions are already very long. Please don't assume anything and write things on your own if it is not asked. Not asked, don't discuss. That's the first rule. Right? You on your own think that, oh, the evidence is weak. Let's discuss submission of no case to answer. You are making your life difficult because the questions are already very, very long. Just now, 2018, that question wasn't long. Right? But after the 2020, or the questions are super long. Right? So please be careful in regards to that. Anybody have any question to ask before I proceed with the next question? Okay. But no comment is stated in the facts of the question in paragraph 1. Yeah, that's why I was finding. Wait, let me see that. Oh, this part, I think you should just admit it was you who killed Jack, don't you? Amal makes no comment to all question put to him in interview. Yeah, so which means that's right. So I was just finding. So that will attract, right, an issue in regards to right to silence, because he said that no comment. See, right to silence is not only about you remaining silent, right? It's not only about you remaining silent. When you say no comment, no comment, no comment, it is actually you are exercising your right to silence. So this is made in a police station. So therefore, you will discuss section 34 of CJPOA. Okay, since I never put it here, I will look at this here. Section 34, CJPOA. It's quite simple actually, right? Can you see section 34? Criminal Justice and Public Order Act 1994. Where in any proceedings against a person for an offense, evidence is given that the accused, at any time before he was charged with the offense, on being questioned under caution by a constable, trying to discover whether or by whom the offense had been committed, failed to mention any facts relied on in his defense in those proceedings, or on being charged with the offense, or officially informed that he might be prosecuted for it, failed to mention any such fact. This part you don't need to read. Being a fact which in circumstances existing at that time, the accused could reasonably have been expected to mention, so question and charge or inform, as the case may be in subsection 2 above applies, blah, 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 may draw adverse inference from such failure as appear proper. Okay. So what section 34 trying to say is very simple. See, section 34 just trying to say, if you fail to mention on being questioned any facts that you rely later, adverse inference may be drawn. Right? That's section 34. That's how much you have to write to the examiner. Now, of course, in all the question, he failed to mention, right, any facts, right or not? Right? That's that question I was looking at. Is this the question that I was looking at? Yes, yeah, that's right. So you fail to mention anything on being questioned. But are you relying on that later in trial? You've made a confession, but obviously the accused won't be relying on his own confession because the accused will always want to exclude the confession. That means, like in police station, I ask you, where were you at the time? You didn't answer. But in court, you're answering. I was at, at Mongkok. Then probably we will ask why you didn't mention this earlier. So adverse inferences can be drawn. Right or not? But right now, he didn't never say anything. Later he confessed. Obviously, he won't rely on his confession. But he is not relying anything in trial that is not really part of the confession. Am I right or not? He's not relying anything on trial that is not part of the confession. Sorry, he's not relying anything on trial that he failed to mention earlier. Do you understand what I'm trying to say? If you rely something on trial that you failed to mention earlier, adverse inferences could be drawn. But what are you relying on trial? You are not relying on anything. You are making submission of no case to answer. So, right to silence here, adverse inferences here cannot be drawn. Because it can be only drawn in a situation where in a police station, I am asking you, where were you? You didn't answer. But in court, you are telling I was at this place. Then the court will ask why you didn't mention this at police station. Then probably we can draw an adverse inference. But we cannot draw an adverse inference, right, when he never mentioned anything in trial. He's submitting for no case to answer. Do you understand? Anybody have any question? In para 3, prosecution seeks to call expert evidence to justify the year print. But D objects that discuss expert evidence. What's the implication of the fact that claiming year printing is not sufficiently reliable? That's a small issue actually, right? I know, I think I missed that in this question, right? Expert evidence is actually an issue of, I told you expert evidence will be admitted when there's a need, when the witness is qualified, suitably qualified. So now we are saying that, see, by following the question, the defense object to admitting expert evidence on the basis that the field of evidence year printing is not sufficiently reliable. I mean, we are trying to say that that field, what is year printing? Have you heard of this before? Where year all got print? Probably got print also, nobody knows. So the defense is telling that this area is not a reliable area. So how there can be an expert on that? We are trying to say that the expert is not suitably qualified. So you just have to tell the examiner, right? There's a need because year pre-null nobody heard of. But if the expert is qualified, the field itself is not sufficiently established. So the expert cannot be qualified, cannot be a properly qualified person. And therefore, the expert evidence cannot be admitted. Expert evidence cannot be admitted. Any issues? Yes, qualification point. That's right. There's a need definitely, but qualification point is a problem. About the right to silence, anybody have any issues? You understand why you don't need to give a current direction, why you don't have to draw an adverse inference, because there's no issue here. Because he did not rely anything on trial that he failed to mention on being questioned. Okay. So now you go down to the next question. Hopefully when I read the question, you know what is the issue, right? Question 7, October 2020 receipt. Aisha reports to the police that her neighbor, Danny, jumped out of a bush on the way home and raped her out of sight of a passerby. The police arrest Danny. Danny says he has not had sex with anyone since being released from prison 2 years ago, and that he wants to see a lawyer before answering any questions. Danny is known to the police, who are aware that Danny will be in a hurry to get out of the police station to satisfy his highly addictive drug habit. PC Fixit lies to Danny by telling him that it will be 18 hours before the lawyer arrives. Right? That's a lie. So there are some, procedural irregularities here. There's also an attack, right, for bad character evidence, because he said that I had never had sex with anybody for the past 2 years. Danny is known to the police, who are aware. Sorry, I read this already. PC Fixit lies to Danny by telling him that it will be 18 hours before the lawyer arrives, which is like almost tantamount to refusal to legal advice, if you see. Because I asked for a lawyer and then you lied to me that it will take 18 hours, right, before the lawyer arrives, which is like a refusal to legal advice. Danny reluctantly agrees to be interviewed. At first, he denies the offense, claiming that Aisha is an alcoholic and a liar. There's another attack, right? Section 101 sub 1G will be automatically, right, triggered here. PC Fixit fires question at Danny for 8 hours. Quote C, procedural irregularity. Calling him useless druggie, who no one would believe. PC Fixit tells Danny he's an idiot because the whole incident has been captured on CCTV, which is a lie. And he's only adding to his sentence by refusing to confess. So this is a lie. Yeah? This is a lie. During the 8th hour of questioning, Danny confesses to raping Aisha and tells the police they will find the condom discarded under some yew trees in the woods. He says that the condom is distinctive because it is a novelty condom. Novelty means new condom, right? Like a unique new condom. As Danny described. Sorry, it's a novelty condom and an unusual shape and color. The police searches the wood and finds a condom as Danny described in the exact place. In the exact place Danny indicated. Forensic scientists are unable to find any material on the condom that would identify its user. So condom is not really showing. Semen traces are not showing. Probably and the semen traces are too dry, right? You cannot find out the DNA structure based on that. Danny is now on trial for rape. He claims that the confession was false and that he was bullied into making it. Danny has 7 previous convictions for rape, to which he pleaded guilty. When you have this type of 7 previous conviction and your current conviction is rape, you know that most likely you're going to prison, right? Because your bad character evidence, right, will add on a lot to the propensity. Not 1 time, 2 time before. 7 times your previous conviction for rape. And how you are going to tell the judge that, I'm a changed man now, I'm a new man, I have a remorse. Impossible. Although it may be unfair, right? I would say that a man who committed rape 7 times before doesn't mean that he can commit rape now. Probably he's a changed man. But trial is political, right? We cannot be like, tolerating this. So 7 previous conviction for rape, to which he pleaded guilty, right? And 1 previous conviction for fraud, to which he pleaded not guilty. Do you know why they are telling guilty, not guilty all? Because Campbell and Henson, under propensity to be untruthful, if you look at Henson, under second part of the test, they say that if you pleaded not guilty, the jury disbelieved you and convicted you. That's the reason, right? They are mentioning that. Discuss any evidential issues arising, adding critical comment where you think the law is unsatisfactory. Again, that's a bloody long question. But nothing beats the earlier questions that we have looked at. That was even more longer. Okay, so first we go to refusal of legal advice. Apparently, he requested for a lawyer, but it was refused. Not refused, but they say that it will take 18 hours for lawyers to arrive, and which turned out to be a lie. So again, you put Crown against LADs, Crown against Samuel, right? What LAD said, what Samuel said, and straight section 58. Remember, LAD said that it's an inalienable right. Then section 58, which stated legal advice can be delayed. Now remember this, I have to tell this to you. Sometimes when I mark my students' answers, they say legal advice can be refused if you satisfy these requirements. That's wrong. Legal advice cannot be refused at any circumstances. It can be only delayed, cannot be refused. Remember that. Do not write in your exam, legal advice can be refused. You may think these are all small things, why he's actually making this big. But let me tell you, the small things are the one which will make you to lose marks. Not the big things. Big things you all know. The small things like this, one word mistake, right? Just you know what you are talking about, but just you never write properly. This simple one word mistake will will make you to drop few marks already. So don't do that. Huh? Legal aid cannot be, sorry, not legal aid. Legal advice cannot be refused. It can be only delayed. Okay. So it's an inductible offense. Superintendent above must authorize it, and these are the reasons. Well, on the facts, definitely it's not superintendent, right? Because the question stated is PC fix it. PC is not superintendent. Then we go to the next part, confession. Can you see confession? So again, it seems that Danny confesses to raping Aisha, right? And by following section 76, confession must be relevant, should not have been excluded under 2A and 2B. So 2A against oppression, you can put 76 of 8 or Crown against Fulling. What was the oppression here? I've indicated. Right? PC fix it. 5 years question at Danny for 8 hours, calling him a useless druggie who no one will believe. Verbal derogatory statement. And PC fix it tells Danny that he's an idiot. Right? Because the whole incident has been captured on CCTV. Is this considered to be an oppression? Remember, oppression need not to be just physical. It can be mental as well. Then 76 of 2B, you have to put the case of Crown against Goldenberg. And remember the 3 requirements. Something said or done must come externally. If something said or done comes externally, all internal characteristics of the accused can be taken into account. Something said or done comes externally, all internal characteristics of the accused can be taken into account, meaning to say that we can say, a drug addict will normally behave to a statement differently than a sober person. We can take that into account. But something said or done must come externally. Then causation, unreliability. So on the fact, something said or done, same thing here. And I would say for this reason, confession may be excluded. Then we have section 78. Now, if you have any doubt here, you can stop me, right? Remember, I'm actually going a little bit fast. The reason is because it's the same thing I'm looking at. We have looked at this many times before, right? So if you have any question, you tell me. I hope by now you have seen the pattern ready, right? Confession, a bit of hearsay, a bit of bad character evidence. That's how every question being asked. So section 78, 82 sub 3, this is procedural irregularity. But there was a lie here actually. For lie, we have Crown against Mason. Where here, the policeman lied to the solicitor. But on the facts, the policeman did not lie to the solicitor. The policeman said that this lied to the defendant. If you lie to the defendant, probably, confession may be excluded, may not be excluded. Lying to solicitor is very big. And section 76 of 4, which is Danny confesses that there's a condom at a place. And apparently the police went there and recovered that. So anything that was recovered as a result of the confession, even if the confession is excluded, right? I repeat, even if the confession is excluded, anything recovered as a result of the confession can be admitted. That is section 76 sub 4A, which stated this. Nothing will prevent the recovery of property even if the confession ruled inadmissible. And 76 sub 5. 76 sub 5 and 6 you don't have to discuss. Right? It will this is like assuming things ready. Right? Anybody have any issues? Then we go to bad character evidence. Right? He has 7 previous convictions for rape. Obviously, the prosecution wants to bring this under section 101 sub 1D. Right? The prosecution wants to bring this under 101 sub 1D. So is this actually a bad character evidence? I put section 98. Section 98 stated bad character evidence is a misconduct. What is a misconduct? It was stated in section 112 sub 1 of CJ 2003. Misconduct means commission of an offense or other reprehensible behavior. On the fact, 7 previous convictions, so definitely it's a commission of an offense. So for the 7 previous convictions for rape, it will come under propensity to commit the offense And we can establish this by following the same description. Because now also rape and last 7 times also rape. Right? And please remember, tell the examiner about these two exclusionary sections. Section 103 sub 3, the court can exclude the evidence by reason of length of time. Section 101 sub 3, if there's an adverse effect to the fairness of the proceedings, the court may actually exclude the evidence. Discretionary section. And you have to give a Henson direction. Anybody still have any problem in regards to Henson direction? For propensity to commit the offense? Okay, great. So now you go to propensity to be untruthful, where again you have to go under test under Campbell, right? Which is telling lies must be an element of the offense charge. Obviously now it's rape. Telling lies is not elements of the offense charge, so Campbell is gone. Remaining is Henson, right? Henson is, in the present case, truthfulness must be an issue. If he's testifying, truthfulness is always an issue. In the earlier case, plea of not guilty and the defendant gave an account on errors and the jury disbelief. Well, apparently, yes, apparently for fraud in the earlier case, he pleaded not guilty. And if you pleaded not guilty, but still you serve prison sentence means the jury disbelieve you, right? The jury disbelieve you. So therefore, we can bring that fraud under propensity to be untruthful by following Crown against Henson. Please remember, always remember that Crown against Henson is the preferable view, not Campbell. Henson is the preferable view. Anybody have any problem? Okay, the last part. Section 101 sub 1G. Right? Remember, Danny said he has not had sex with anyone since being released from prison 2 years ago. Well, although it is maybe something that you innocently said, but it means that you are, as per the court, you are claiming that witness is a liar or victim is a liar, right? Because how come you never had sex, but she's telling that you raped her, right? So, Crown against Singh, James Paul. An attack is made for the purpose of this gateway, even though it is necessary part of the defendant's case. Therefore, 101 sub 1G is applicable here. Anybody have any issues? Okay, so today we have looked at 4 questions. Yesterday, 4 questions, 8. Tomorrow, I will look at the article summary. I'll also look at essay questions. 2023 problem solving question if I have time. Otherwise, I'll just give the handout to you because I'll look at probably 1 question from 2023. Essay question from 2023, I will look at, right? But problem solving question, I will look at probably 1 or 2. Essay question, I will look at 1 or 2. Then I will discuss the article with you because I really think a RAG ST gonna come out, right? Normally, whatever in recent development will be repeated in the exam. So I'll provide you the article summary. The article summary is a small issue, right? As long as you know that, you can discuss. Any issues? Anybody have any problem? No issues. May I go back to question number 5? Yes, question number 5. Oh, the Jack question, right? 2018. Yes, this is the question. Yes. Wait, let me share that question. Yes. What is your doubt in regards to this? Hold on, I'm waiting for the question. To clarify, section 34 is not applicable because Amal has nothing to rely on. Even Amal has made no comment. Because Amal seeks no case to answer. No, not because Amal seeks no case to answer. No, that's not what I said. What I said was, Amal seeks no case to answer, yes, right? But section 34 is applicable when you are silent at police station, being questioned, but you are relying or giving an answer on whatever was asked in police station at court. That means in police station, I am asking you, right, where were you at the crime scene? You say no comment. But in court, I'm saying that, Judge, I was actually at my mother-in-law's house. So, section 34 is applicable here. Why? Because the court will now ask, why you didn't mention this at police station and police asks? Why you say no comment? Right? So, that's again, it's not applicable to all the questions. Section 34 stated, if you remain silent, right, on anything that you reasonably expected to mention, and you are relying on that in court later, then adverse inferences could be drawn. Like, what is reasonable to mention? If I just ask you, where were you? Probably it's reasonable to mention. If I ask you, what is your name? It's reasonable to mention what? You say no comment. And then later, you are telling your name is John in court. So the court will ask, why you didn't say this earlier? Because it was reasonable to mention your name. What? So in our facts, Amal made a confession, right? But confession is not something Amal will rely in court. Confession is something that Amal wants to exclude. So Amal made a no comment in police station. But what is he relying in court? He's not relying on anything in court. He's excluding his confession. Right? If he's relying on court on something that he failed to mention at police station, then adverse inferences can be drawn. Now, he made a no comment interview at police station, but he is not relying on that. Whatever he failed to mention at police station, at court. So, adverse inferences cannot be drawn here. That's what I said. You understand? Well, I didn't go into right to silence in detail with you. The reason is because right to silence is not really part of our 3 days. The reason why I'm discussing right to silence is because it's part of the question. So I don't want to, skip that one part because I'm not doing that. I want to give whole question to you. But right to silence will be explained further in your another revision with Ms. Subhana. But of course, if you have any question on whatever that even I don't teach, you can ask me, no problem. Got it? Okay, that's great. Any other question? Okay, so if no question, then I'll meet you again tomorrow, 7 o'clock, right? For a 3-hour session. Thank you. Good night. Bye.